morning, everyone. I call this meeting to order. And just before we get underway, given the way that things were going on Tuesday and given that we've agreed to 2 meetings for clause by clause, I used my discretion to convene this meeting at 10 a.m. Thank you. And just a reference to the Green Book on page 1095. Committee meetings are convened by the chair acting either on a decision made by the committee or at the chair's own authority. Just a couple of housekeeping rules as we continue to go clause by clause on Bill C7. Note that we are in a hybrid format. The proceedings will be made available via the House of Commons website, and the person who is speaking is the person that will be appearing on the webcast instead of the entirety of the committee. So, as always, members and witnesses, please speak in your official language. Interpretation is available for you at the bottom of the screen. I'm appearing in person only today, it seems, and I'll be following the health protocols as required. I'll ask members before speaking, please wait until I recognize you by name. And unmute yourself using the microphone icon. And when you're not speaking, please speak. When you're not speaking, just make sure that you're on mute. And when you are speaking, please speak slowly and clearly so that interpretation is available. With regard to the speaking list, as always, you can raise your hand. I see that there's a couple raised already. You can raise your hand with that blue raise hand function on your Zoom screen. There are no members in the room, but the clerk and I will do our best to maintain a good speaking list and a speaking order. And then we do have our witnesses today very quickly from the Department of Justice. We have Joanne Kleinberg, Department of Justice, Caroline Quesnel, Department of Health, Abby Hoffman, Department of Health, Sharon Harper, and also from the Department of Health, Karen Cush. And so we had left off at the last meeting on in the middle of debate on BQ3. And I had Mr. Kellaway, who was the last standing speaker before the meeting was adjourned on Tuesday. So we shall go to Mr. Kellaway, and then I see
Madam
that
Chair,
yes, Madam Finlay.
I have my hand raised and had it raised.
Yes, I see that. We're just continuing from the meeting from last.
Privilege, Madam Chair. I have a point of privilege.
You have a point of privilege. Okay, please go ahead.
I do. I am frankly very distressed about how this meeting today has been handled. And I feel that as a member of Parliament, this is a matter of privilege for me. I had a notice of meeting at 5:51 a.m. I am a British Columbia member. And at 5:51 a.m. yesterday, I received a notice of meeting that said that this meeting was going to proceed at the normal time, which for you in Ontario may be 11 o'clock, but for me in British Columbia is 8 o'clock. To have it moved to an hour earlier at the end of the day, I received the second notice of meeting came in my time, 2:18 p.m., which is 5:18 p.m. Ontario time. So I wasn't expecting after the normal close of business day from Ontario to receive another notice without consultation, without discussion, without any kind of warning. And in fact, my whole day from early in the morning, 6:30 in fact yesterday, was all scheduled right up until 7 p.m. in the evening. So I didn't see the second notice of meeting, which I wasn't expecting until the evening, last evening, requiring me to be here for a whole hour earlier. Now, just to put that in context, in order for me to get into my constituency office where I am now, where all my binders are, because this is important committee work. This isn't something where I can just plug in and listen. I have to have my binders ready, like you all do. I have to have all the amendments in front of me. I have to be ready to go. So in order for me to get from the time I get up, frankly, until I drive to my constituency office is over an hour. So for me to start with a committee meeting a whole hour early with extremely short notice means that I'm getting up at 5:15 in the morning. And I realize there's some other people here on this call who are from British Columbia as well. And I don't know their personal circumstances. I don't know how far they live from their constituency offices, or maybe they've got this all set up at home. But I don't have all this set up at home. You go through a long monologue before every meeting about hybrid sessions, and we've agreed in the present circumstances to be sitting in a hybrid session. There should be more flexibility and more courtesy paid, frankly, to those of us in a time zone that's 3 hours earlier with respect to how we attend these meetings, how we prepare for these meetings, and what it is required of us. I want to be prepared. I want to be ready. I don't want to waste time once I'm here. And so this is the way one has to say. With all due respect, Madam Chair, you may have the ultimate authority to do this. I don't even know if you do. You're telling us you do. But to do it on such short notice, to do it after a notice of meeting with the normal time was already sent out and people's schedules are set. I'm 3 hours earlier. I know there's people on this call who are an hour later or an hour and a half later, perhaps. Everyone is busy. Everyone has schedules. And by doing what you've done in this arbitrary fashion, I don't believe there was a subcommittee meeting or even a request for one, leaves me at a distinct disadvantage. My understanding is that the whole idea here should be one where we work together, we cooperate together, we recognize that it is necessary to do certain things for us to carry out our duties and our responsibilities. This is a very big country. There's a lot of people watching these proceedings who are vitally interested in a piece of legislation that is going to dramatically change the health, living and dying landscape for Canadians from coast to coast to coast. And in that manner, to take a unilateral action announced at the end of the day, and expect us to just adjust everything and be ready to go for me very early in the morning. Mr. Manley said something about maybe the sun coming up. He's from Nanaimo Ladysmith, which, by the way, is my hometown, Mr. Manley. But I looked out the window and it was completely dark and a very empty parking lot here because obviously the sun comes up on Vancouver Island before it hits the mainland. But you know, these are the realities of trying to do these committee meetings with in hybrid settings. We're all doing our best, but with all due respect for those of you in Ontario, you can or sitting in Ontario right now, you can't just do this and expect people in a 3-hour different time zone to just adjust on a moment's notice. It's not fair. It's a huge barrier to my full participation in committee meetings. It interferes and impedes my ability to participate fully as a member of Parliament. That is my right and privilege as an elected official, and to voice the concerns of my constituents, of which particularly on this bill, there are many, as we've heard in witness testimony and in our discussions so far. And I appreciate that on the government side, you want all this to happen really quickly. But this is a very, very important piece of legislation. And it was your party, with all respect, who prorogued Parliament. You did not do the review in June that you should have. My colleague, our colleague, Mr. Garrison, is completely right that should have gone ahead and should now go ahead in an expedient manner, because you're now trying to push us even to the point of, in my view, a breach of my privilege to get something through that there was time to do, There was time to hear more witnesses. There was time to do this in a proper way. And now you're acting as though, you can just do what you want. Go ahead. I sat on the Justice Committee before in an earlier parliament. In fact, I had Mr. Virani's role, and I know it's a tough one, so I send you my heartfelt sympathies, Mr. Virani, because it's a big job, and I did it for 2 years. And never once in that 2 years did the chair of the Justice Committee at that time do something like this. And that's when we were all able to be there in person. This is not the way to foster cooperation. It's not the way to have us move forward in a timely, cooperative fashion. This, and frankly, once a notice of meeting is sent, I don't think anyone is sitting by their computer waiting 12 hours later to get a different one. I could very easily have missed this. The reason I didn't was because my colleague, Mr. Moore, sent an email about it, and I looked at his email. I had no reason to look at a further notice of meeting thinking that it was different. And because it was so late in the day, as I said, I didn't even see it till yesterday evening. So I want this point of privilege to be regarded, and I want to, frankly, hear some discussion, because I don't think we can continue in this kind of manner. There's two things that I'm looking for from you. I will move a motion to report this matter of privilege to the House, to report your actions. I really don't want to do that because it could delay important proceedings before this committee. I'd rather deal with it here and now by you unbreaching my privileges with the following three actions. First, I think you should apologize for unilaterally impeding my ability to fully participate in this committee by your end of day, short notice, readjustment of the committee's meeting time. Two, you agree publicly right now to never unilaterally move the start time of a committee meeting unless so ordered by this committee. That at least should be a matter of prior discussion. It shouldn't be done, not earlier. It's one thing when we're getting into it and you canvass the committee and we say, look, we're all willing to sit another 15 minutes, another 30 minutes. But to do it earlier in a hybrid setting when you've got British Columbia members, that's not right. And it is our duty and our job to have everything set up. We've been told this over and over again. If I don't have proper Wi-Fi, if I don't have a proper setup, that's on me. So for me, I have to go into my constituency office because I cannot always rely on my connectivity at my home. So I don't have that option. Three, that you confirm on the record, at risk of contempt of Parliament if you do not provide the full truth, that you had zero conversation with the Minister of Justice, his staff, the Prime Minister or his staff, or the House Leader, Whip, and their respective staff, where the topic of moving this committee meeting to 10 a.m. was discussed. Thank you.
Thanks for that, Madam Findlay. I have Mr. Maloney next on the list. Go ahead, Mr. Maloney.
Thank you, Madam Chair. Just in response to what Ms. Findlay said, let me start by saying thank you. Thank you for your comments and expressing your concerns, and thank you for highlighting the need to be flexible and work together, because I couldn't agree with you more. It's absolutely vital that we do so on a regular basis, but it's particularly heightened now in circumstances where we are in the midst of a pandemic and we are working in a hybrid situation. And the hybrid situation, one of the consequences of that is that we have to deal with time zones when there's something we don't have to deal with when we're all sitting in Ottawa. I regularly remind my caucus colleagues from British Columbia who represent ridings in beautiful British Columbia that one of the penalties for living in such a beautiful place is that sometimes you have to get up earlier than I do. And I say that jokingly, but we're all have to be flexible. We've all had to adapt. We've had votes at 1 a.m. In this session already, which are much more difficult for those of us in Ontario or for people like Mr. Moore in New Brunswick than they are for people in British Columbia. So what I'm saying is I understand where you're coming from. I'm grateful for your comments. I thank you. But the chair does have the right to call a meeting at her discretion and at the time that she so chooses. So you also pointed out and reminded us how important this legislation is and that we have to deal with it on an expedited basis because of the court imposed deadline. You also mentioned that if we get involved in process dealing with points of privilege and whatnot, it could delay that process, which would be very unfortunate to say the least. You're here now, for which we are all grateful. And Mr. Manley, the same applies to you. I know it's very early in the morning. I would hope that given the fact that we're here and in these very highly unusual circumstances, that we can get down to work and start meeting. We can have a more thorough discussion about timing of meetings and whatnot. But for today's purposes, I'd like to see us move forward. But we all do appreciate you making the effort, Ms. Finley, so thank you.
Thank you, Mr. Maloney. I have Mr. Moore next on the speaking list on this same point of order. Go ahead, Mr. Moore.
Thank you, Madam Chair. I believe that Mrs. Finley.
Excuse me, Madam Chair and Rob, it is a point of privilege, not a point of order.
Thank you for that clarification. Go ahead, Mr. Moore.
Yeah, just on this, look, we've spent some time together as a committee, and I appreciate the efforts of everybody on this committee. We're all representing different parties and to have different views on things, but this is in Parliament, this is where some of the real work can take place. And I hope that we come to the committee with an open mind on things and a willingness to work together away from the cut and thrust of what happens in question period, where we can behave in a collegial manner with each other within the rules that this House sets out, within the rules that we establish as a committee. And one of the things that was set out very early when we came together was that the committee would meet from 11 to 1 Eastern time. And I appreciate MP Finley's intervention of what, Eastern time means something different here in Atlantic, and it means something way different in British Columbia. And I appreciate the efforts everyone makes to participate. And we're in uncharted territory with all of us learning to do Zoom. And I appreciate Mr. Maloney's comments. And one of the key things, and we hear this from our speaker as well, one of the key things that's going to enable us to move forward constructively as a House of Commons and as a committee is that we have a rules-based system. And late yesterday, I was participating in another committee, received this notice. And to be honest, I didn't even realize the time had been changed. There'd been no effort whatsoever. I'm sure each and every one, Madam Chair and all committee members, if you have a regularly scheduled meeting and something happens that meeting time has to be delayed or changed in some way, it's a basic courtesy in the notice that would go out would be to say, hey, members, just a notice that the meeting's starting an hour early. Now, I won't get to that. That's without even getting to how this came about. So common courtesy was overlooked. We all have each other's emails. Last night when this came out, Madam Chair, I sent you an email. I've raised this before when the meetings go overtime. We've agreed, we're working constructively on this bill, C7. We had great discussion at the last meeting on the amendments, and presumably we're going to have a discussion on the bill and amendments today. But I presume, having been an MP for a number of years, that each and every one of you, and as members of this committee, have busy schedules. That's one of the things we accept as members of parliament, that whether it's with constituents, whether it's our parliamentary duties, whether you're a parliamentary secretary or a chair or a member of a committee or a minister, whatever role you play in this parliament, we're all busy. And one of the things we do is we balance that personal life, the role we have in our constituencies, the role we have in Ottawa, and we balance. And the way we balance, most of us, is with our calendar. So if in my calendar it says a meeting is from 11 till 1, I mean, this is how it works in the business world. It's how it works everywhere. And in my experience, as a parliamentarian, as a former chair of a committee, as a former parliamentary secretary, in my experience, 99% of the time, that's how it works. The meeting starts when you say it's going to start, and when it ends, everyone usually scurries off because we all have something else to do. For example, this morning, I had a meeting scheduled for 10 o'clock. 10 o'clock Eastern time, which is 11 o'clock Atlantic time. I had a meeting scheduled. When that notice came out, when it was brought to my attention that the meeting time had changed, I didn't see it when I received the notice on my email. When it came to my attention that the meeting had been changed, my staff, after hours, after some of them had already gone home, my staff had to make adjustments and let the people know that I was meeting with at 10 o'clock, let them know that I couldn't have that meeting because something came out outside of my control. It's just basic common courtesy. I wouldn't want anyone to be under the illusion that somehow manipulating things at the last minute would somehow move things along faster. I think if anything, if we can't trust each other around the table, I get that we have different roles to play. I get that some of us like this bill, some of us don't. I hope that we're all working in the best interest of Canadians, and we're going to get to that. But we may be together as a committee for who knows how long. I don't know. We don't know when the next election is. We don't know how long we're each going to be in our respective roles, but we may be working together as a committee. The only way that this is going to work is if, when we agree on something like this, that at the last minute it doesn't change. I want to draw, Madam Chair, I want to draw your attention. I've heard from other chairs, I've heard from the whips that when these meetings are set, there's limited House resources. When these meetings are set, that it's done with the whips' approval. Like the whips of our respective parties make the decision on when our meetings are. We abide by that. I spoke personally with the whip of the Conservative Party, who told me that this was the first he was hearing about it. He didn't know that the meeting had been changed. And I refuse to believe that maybe everyone was in the dark. I don't think everyone was in the dark. I know Conservatives were in the dark. I know we just barely would have even been on here had it not been brought to my attention that the meeting started an hour early. And I frankly would think that there was discussions among some members of this committee about moving the meeting at the last minute an hour early. That is not respectful of the people around this table or this virtual table. It's not respectful to each other as colleagues. And I endorse what MP Findlay has said in her question of personal privilege, that we can't conduct ourselves this way. This is why we have Marleau and Montpetit. It's why we abide by a certain set of rules. It's why speakers make rulings and we abide by those rulings. It's why we make decisions together, and we have a rules-based system. Am I to believe that on days when Justice Committee is scheduled, or perhaps even days when it isn't scheduled, that I should book the whole day off? That I don't know when the meeting will start and I don't know when the meeting will end? We cannot operate that way. So I want to endorse what's been said, and I want to say that I'm willing to work together with everybody. I think we all have our nation's and our constituents' best interest at heart, even though our views are different on different things. This is where we have the opportunity to put a lot of the things aside that happened in the chamber and happened in the media and get some real work done. And we have a willingness to work together, but we have to abide by the rules and the schedules that we set out. If like as of today, my schedule says this meeting ends at 1 o'clock. This meeting needs to end at 1 o'clock. If there's unfinished business, we could all look. Why is there unfinished business? Well, it could be because the House was prorogued. It could be because the government is looking at this deadline that was imposed, that's been extended a number of times. We as parliamentarians, I know we've all been receiving. I've received emails from people that would have liked to have spoke at committee. It became very clear to me as we heard committee testimony on C7 that of course it's a complicated issue. We all knew that when we went into it, but we heard some very interesting perspectives from people from physicians, from people in palliative care, from specialists that deal with people, from people, persons with disabilities who spoke through their organizations unanimously and who spoke as individuals before this committee. Rather than talking about the fact that we may have had a breach of our privilege as parliamentarians, it would have been good to hear from more witnesses. But instead, we haven't heard enough from witnesses, and now we're spending time on this wrangling. So I think it's important that we have this conversation now, because this is going to impact how we work together going forward. And I do want to say that I'm completely willing to work with everyone, but we have to have good faith and we have to have a rules-based system. And sending out a notice without any kind of red flag, like take special notice, there's a different time. If it wasn't brought to your personal attention, I suspect that many of us wouldn't be logging on for another 20 minutes and then find out that the meeting was already taking place. I think that there were conversations. I believe that there was. And Madam Chair, I would like an answer to MP Finley's question is, did you have those conversations with whether it's parliamentary secretary, the whip's office, the House Leader's office of your party, and not have even a courtesy call, a courtesy email, a courtesy text with members of the Conservative Party? As I mentioned, I emailed, Madam Chair, I emailed you last night with the suggestion that I'm sure, like me, many people already had things booked. Like if you ask me about tomorrow, I have things scheduled for tomorrow. So if something came up that I had to deal with, it would involve moving things around. And likewise, most of us probably had things scheduled this morning, unless we knew in advance that this was going to happen. I didn't know in advance. So I ask you to consider that, Madam Chair. I ask members of the committee that we work together in good faith, and that that how we conduct ourselves on this bill is absolutely going to impact how we work together going forward. We have the opportunity, I believe, to do some really good work together, some important work for Canadians and for this Parliament. That's what we're all elected here to do. But like we've seen so often in other countries that don't have a rules-based system, that's one of the beauties of Canada. We have the rule of law. Parliament is the keeper of these laws. We make laws here. And we expect Canadians to follow rules. We wouldn't pull the rug out from under a Canadian. We wouldn't expect that, where there's one rule one day and then the next day there's a different rule. We expect Canadians to abide by the rules. Well, likewise, we as parliamentarians, we have to abide by the rules. And the way we're conducting ourselves at Justice Committee is that we have our scheduled meetings. We don't take advantage of each other's time by extending a meeting without any notice, starting a meeting an hour early with barely any notice. We have respect for each other and we operate under the rules. I would have, if Madam Chair, if you or any other member of this committee, as a matter of fact, another member from another party did reach out to me on an issue, and I'd be happy to take a call, happy to take an email, happy to respond with my thoughts, happy to have that discussion. But we just can't conduct ourselves this way. So, Madam Chair, I ask that you give some type of response to Madam Finley's question of privilege as well. Thank you, and certainly do look forward to working with everybody on this and other things in the future.
Thank you for that, Mr. Moore. Mr. Cooper, I have you next.
Well, thank you very much, Madam Chair, and I just wish to speak in support of the points that have been raised by Ms. Findlay. I want to say at the outset that I have a lot of respect for you, Madam Chair. We have served on the Justice Committee through the entirety of the last Parliament, and I know you as a colleague, someone who I believe is doing your best to try to work cooperatively with members and to make this committee work as best as possible. I know that in the last Parliament, in the Justice Committee, we dealt with some pretty significant pieces of legislation, including the predecessor to Bill C-7, namely Bill C-14. And I know that throughout there was certainly disagreements on policy, disagreements on broad issues. But one of the things that I really appreciated about this committee is that we could look at the issues before us, the legislation before us, in a serious way. That didn't mean putting aside partisanship, because there are legitimate differences. But we worked together in a collegial way, and I believe all members of the committee, regardless of their perspectives, worked in good faith together. And I guess what is disappointing, with, again, the greatest of respect that I have for you, is that this, as Mr. Moore said, we are based upon a rules-based system. We need to respect members' schedules and their time commitments. And I can say that in the 4.5, almost 5 years now that I've been a member of Parliament, I have never been in a situation where the chair of a committee unilaterally called a meeting prior to the agreed upon schedule. I talked to Mr. Moore last night, who served here for 11 years, from 2004 until 2015, and then since 2019, 12 years in this place. And he noted that he had never seen anything quite like this. And I can tell you that in terms of my schedule, this has caused actually quite a bit of disruption. In fact, I had a press conference that had been scheduled for 10 a.m. It was ready to go. There were a number of stakeholders who were prepared to attend that press conference at that scheduled time. I happened to find out about this scheduling change around 6 o'clock last night. I happened to find out from another member who I was working with to coordinate the press conference. As a result, we had to completely rearrange the schedules of multiple individuals, causing considerable inconvenience. Had I not been moving ahead with a press conference, I might not have even heard that the committee schedule had been changed. Now, it's true you sent out an email, but I think there should be a reasonable expectation amongst all members that we shouldn't have to look at our email every 10 minutes or every hour because somewhere out of thin air, a committee meeting is going to be called. Indeed, in terms of this committee schedule, the whips of all parties had agreed that committees that fit within our time slot are to meet no earlier than 11 a.m. And part of the reason for that is because of time zone issues and the considerable issues that it causes members who are living in the West Coast, a 3-hour time zone change. I mean, Ms. Findlay had to be here at 7 a.m. Had I not been here in Ottawa, it would have been 8 a.m. for me in Edmonton. And I guess what this illustrates, again, not out of any disrespect to you, Madam Chair, is the process involving Bill C-7. At every step of the way, the government has sought to ram this legislation through without meaningful consultation of experts, of physicians, of key stakeholders. And we've had 4 meetings that have provided limited opportunity to hear from witnesses on a whole range of concerns that have been raised from the disabilities rights community, from many health professionals, from the UN Special Rapporteur on the Rights of Persons with Disabilities. We have seen, and in fact, the press conference that I held today, and it's a point that I do want to raise after we deal with the question of privilege brought forward by Ms. Findlay, are the voices of physicians who sought to submit briefs to this committee, whose briefs were rejected because of an arbitrary deadline to submit briefs that no one knew about, other than perhaps the Liberals. And so this speaks to a process that is fundamentally flawed, and it cannot stand. And so I hope, Madam Chair, that you will take the concerns that have been raised, I believe, in good faith by my colleagues, in particular Ms. Findlay, who has raised a number of substantive points seriously, and that we will, going forward, govern ourselves in a way where we abide by schedules. And at the very least in the circumstances, it would seem to me to be appropriate that the vice chairs would have been consulted, but that didn't even happen. And so here we are, members spread out across the country, having to completely rearrange our schedules to deal with what is one of the most complex and important issues before Parliament. And so I think that the point of privilege raised by Ms. Findlay needs to be dealt with. And going forward, I think there needs to be the assurance provided to all members that we will stick to the allotted schedule. I think that if we simply stick to the allotted schedule, we will avoid these issues from arising. I mean, we've had issues, as Mr. Moore noted, where the meeting went over schedule, and I know in part sometimes it was your effort to try to accommodate members, but nonetheless, it creates issues. And so, I hope that going forward, we will abide by our schedules, and that with that understanding, we can work in a collegial way to disagree where necessary, but to have a level of respect that I think is so important for this committee to function in a way that I think all Canadians would hope us to function in, dealing with the very important issues that are before our committee. So thank you, Madam Chair.
Thanks for that, Mr. Cooper. I have Mr. Lewis next on the list. Go ahead, Mr. Lewis.
Thank you, Madam Chair. I appreciate the opportunity to speak to this, and my heart definitely goes out to our good colleagues of every party on the West Coast. Madam Chair, I in my previous career, I traveled across Canada, quite frankly, North America, and obviously by plane. And although I could do a lot of work over the phone, I did a whole bunch of work in one-on-one meetings with various stakeholders. And I'll tell you, Madam Chair, as obviously being from Ontario, I went both east and I went west, and the time zones certainly get to you. So that's why I'm saying I can appreciate our friends to the west as well as to the east, because our schedules are incredibly tight. And I know when I was doing my sales job, you never quite knew what time of the day it was. And Madam Chair, the other thing I would never do, though, is at the very last minute the night before, unless a flight was canceled, quite frankly, was never change a meeting at the last minute. I found out about 7:45 last night from my chief of staff that this meeting had been changed. And so why is that important? Well, I'll tell you exactly why. Why I'm disappointed this morning is this. I had the most amazing Zoom meeting with a young woman from my riding, as well as a teacher in her classroom. And it was a meeting purely to say hi, but more importantly, to give inspiration, to say everything is possible. Go change the world, leave the world a better place than you found it. That was the cusp of the meeting. It's been scheduled for a week. And I had to cut that meeting short because of this meeting. And that's not fair. It's not fair to the grade 6 class that they didn't get more time to be with their MP. There's a reason that I booked it for that time. So I didn't bring that up to the class because I didn't want to show frustration, but it's the real cusp of disrespect, all due respect, disrespect to MPs. When we're trying to reach out, everybody's incredibly busy. I find it appalling that this is happening. Again, Madam Chair, I had the pleasure and the honor to sit on international trade prior to this. And that was right in the heart smack of CUSMA. And I will tell you that we sat for days, for 8 and 10 hours a day, for days, to rush legislation through. And everybody on that committee agreed that we would sit for days and hours to rush the legislation through because it had to be done. The second bit of legislation now that I see being rushed through is made. But the one thing that never happened on international trade, the chair never ever changed the times. Now, if we go back to an email that I got back on November the 6th, I believe the whips all came together and agreed that Justice Committee would be on Tuesday at 11 a.m. to 1 p.m. or 11 a.m. to 1 p.m. and on Thursday from 11 a.m. to 1 p.m. Nowhere in there do I see the email that says anything different. I have to be very honest with you. I think it's incredibly disrespectful that Mr. Moore did not get a response to his email last night that was sent out, be it from yourself, Madam Chair, or somebody else. I think that's incredibly disrespectful. I guess in closing, it kind of goes like this. If I did this to one of my constituents, if I just decided to turn the channel and do this to them, I would probably be out of a job. And I think at the very least, Ms. Finley deserves nothing shy of an apology on this front, as well as our other colleagues from the West. And again, I have the utmost respect for you, Madam Chair. I truly do. And I realize this legislation is very important. But at the same time, we have to be methodical, we have to be strategic, and we have to have open conversation about this. But that open conversation could have happened when government was prorogued. But to disrupt MPs and their schedules is completely disrespectful. The last thing I would leave you with is this, Madam Chair, and we can all agree on this. I'm supposed to have house duty this morning. At the 11th hour, I've got to find somebody to cover house duty for me. And each and every one of us know exactly what that means. So at 8 o'clock last night, I'm trying to scramble around to get somebody to cover house duty, not from 11 to 1, but prior to that. And that's the disrespect that I'm talking about, because usually after dinner, I make phone calls to constituents. Instead, they don't get to hear from me because I'm trying to find somebody to cover. So that's where I come from on this front, and I really appreciate the fact that you're giving me the opportunity to speak. So, Madam Chair, thank you very much. Again, utmost respect to you. I know you're trying to do your job, but I think it's important that collectively we all get C7 right, because when the next bills come forward, we're going to be in the exact same boat again. Thank you, Madam Chair.
Thank you for that, Mr. Lewis. I do have Madam Finley's hand raised, and then I'll stop there and respond. So go ahead, Madam Finley.
Thank you, Madam Chair. I wanted to mention a reality that is important to this discussion and my point of privilege, which I didn't mention before. I happen to be in the Lower Mainland of British Columbia. In the Lower Mainland, we have had a spike in COVID cases in both the Fraser Health Authority and the Coastal Health Authority. We are actually, by provincial mandate, quite locked down here right now, which means I can't, at the moment, I'm not even supposed to travel. I couldn't go visit Mr. Manley or Mr. Garrison on Vancouver Island, even if I wanted to right now. They haven't invited me, but if they did, I couldn't say yes. And on top of that, that means that I have staffing issues. We're not running our offices as normal with a full complement. So by putting a meeting unilaterally an hour earlier, there's no way I have anyone here in this office with me. I have no staff around me. I have no one able to take last minute things. My staff didn't even see your second notice. I saw it as I stopped my car after a meeting in the dark at the other end of the
Point of order, Madam Chair.
Yes.
A point of order.
Mr. Maloney?
Thank you, Madam Chair.
No,
Look,
that is not allowable. That is not allowable, Madam Chair.
It is allowable.
A point of order does not take precedence over a point of privilege.
Sorry, I'm going to allow the point of order.
With the clerk.
Go ahead, Mr. Maloney.
I challenge the chair on
Madam
that.
Chair.
That is not allowed.
Thank you, Madam Chair. We
challenge
have
you.
we have exhaustively now heard all of the reasons why our opposition colleagues are displeased with your decision, which was properly made, to call the meeting an hour earlier. They have effectively delayed the meeting to now almost 11 o'clock, which I expect was their objective. If there is a motion to be tabled by Ms. Finley or anybody else on this issue, I request that they do so now and that we move on so that there's no further delay.
Well, first of all, it is my understanding that a point of order does not supersede a point of privilege, and I would ask the chair to consult with the clerk on that. And secondly, I did put forward a motion and asked for specific action, but I wanted to put my point of privilege in full context, which I was stopped from doing by MP Maloney.
Thank you, Madam Finley. I'm just going to ask Mr. Clerk to just respond to your procedural question there. Go ahead, Mr. Clerk.
Well, thank you, Madam Chair. I was telling the chair that there might be a confusion with what happens usually in the House of Commons when there's a motion of privilege that is allowed to be moved by the Speaker of the House. Yes, that takes precedence over almost all other item of business at the House of Commons, but the same kind of practice or rule doesn't necessarily apply in the committee's universe, especially since maybe I'm wrong, but I don't think that Ms. Finley has moved yet a motion about privilege. So this is why I was saying to the chair that it doesn't take any precedence right now over all other committee business. Thank you.
Thank you, Mr. Clerk. So at this time, Madam Finley, if you would like to move your motion, you're welcome to do so.
Yes, I do. I thought I was giving a way to deal with this here at committee by asking for an apology and asking that that this does not happen again in a unilateral decision. And I also asked for your confirmation on the record as to who you had conversations with that led you to make that unilateral decision. So I move a motion to report this matter of privilege to the House. I did say all this before, to report your actions because I haven't heard any response yet.
Thank you, Madam Finley. And just to clarify, and as I said at the beginning of the meeting, under our routine motions that we passed at the beginning of our committee convening, and according to the rules in the House and Procedure books, I do have the authority to call meetings. And the reason I did so was to ensure, as was concerns raised by members in this committee who have spoken today about having to come in an hour earlier, was to make sure that everybody had that opportunity. We had agreed that we were going to have a set number of meetings for clause by clause. Given the nature of debate at the last meeting, I felt it may be appreciated if members, could have that extra hour to continue the debate on this very important legislation. But I do thank the members for your understanding and for being here today. We'll call the vote we'll call the vote at this time. Then, thank you, Madam Finley.
So you prefer to proceed with my motion rather than apologize. All right, thank you.
There's no further debate. We'll just call the question, sir.
Okay, then. Mr. Cooper?
In support.
Ms. Finley?
In support?
Monsieur Thériault?
Contre.
Against. You are against, is that right? I'm
against the motion.
I'm against the motion.
Mr. Garrison?
Against.
Okay. Mr. Kellaway?
Against.
Mr. Lewis?
I'm in favor.
Mr. Maloney?
Against.
Mr. Moore?
In favor.
Mr. Sanga?
Against.
Mr. Virani?
Against.
Mr. Zuberi?
Respectfully against.
So, yeas pour 7, et nays contre. Pardon. Yeas pour 4, 4, et nays contre 7.
Thank you, Mr. Clerk. So that defeats the motion. Thank you to the members for your healthy discussion this morning. We'll go on now to clause by clause.
Point of order, Madam
yes,
Chair.
Mr. Cooper.
And I'm going to be very brief because I know we want to get to the amendments on C7. But I'm going to put forward a motion. But before I do, I just want to note that a number of physicians had sought to put forward briefs to this committee to provide their expertise and opinion on the legislation. And when they submitted those briefs to the clerk, they were rejected on the basis that they did not meet a deadline. The deadline being apparently midnight of November 12th. Now, that was not a deadline that I was aware of. It was not a deadline any of our colleagues, certainly on the Conservative side, were aware of. It's not a deadline that the physicians were aware of or that the public was informed about. And so, just very simply, in light of this, I think it's important that their voices be heard, and that this be remedied by simply allowing those briefs that were rejected to be submitted. And with that, I would put forward a motion to make those briefs allowable.
Thank you for that, Mr. Cooper. I don't see any. Ms. Finley, is that your hand raised to speak to this issue? No? Okay, so I don't see any hands raised. I will just call the question at this time. Go ahead, Mr. Clerk.
Mr. Cooper,
In support.
Ms. Finley,
In support.
Monsieur Thériault,
Mr. Thériault? Mr. Thériault, are you there? I'm for.
Mr. Garrison,
In favor.
Mr. Calloway,
In favor.
Mr. Lewis,
I'm in favor.
Mr. Maloney,
I will support Mr. Cooper's flexibility. Yes.
Mr. Moore,
Support.
Mr. Sangha,
Against.
Mr. Virani,
Support.
Mr. Zuberi.
Support.
Okay, so in favor 10, 10, et nays 1.
Thank you. So the motion is carried. I appreciate you raising that, Mr. Cooper. Thank you. So we'll continue now with Bloc Québécois 3. This is the amendment on page 6. We had, my understanding is, finished our speakers list on at the last meeting, but I see that Mr. Moore, you'd like to speak to this? Go ahead, sir.
Yes, thanks, Madam Chair. I think at the last meeting I was in the midst of speaking to this particular amendment at the time of the ending of the meeting. I think for all of us, this is an opportunity to provide some clarity, grounded in witness testimony. Some of the testimony that I've been receiving on this bill around the phrase that's really under C14 and now under C7 is so important, and that's reasonably foreseeable. There is no definition of reasonably foreseeable. I heard argument on this particular clause, BQ3, this particular amendment, that somehow it could possibly be less certainty, but I think that just the opposite is, it's abundantly clear that just the opposite would be true, and that is that by us as parliamentarians putting in this amount of 12 months, we've got, it's paramount to this bill because it involves which track someone who's seeking medical assistance in dying, it involves which track they're going to be on. We say in Bill C7 that if your death is reasonably foreseeable, then there's certain safeguards in place. Less safeguards than were there under C14. Under C14, there was the safeguards that there had to be two independent witnesses, that there was a 10-day reflection period. There was other safeguards that in fact C7 takes out that were in C14. But if your death is not reasonably foreseeable, then you're on another track. And those of us that have studied this this bill know this. So the whole bill turns on reasonable foreseeability. And in my readings on this and speaking with physicians and seeing briefs from physicians and from those in the disability community, as well, hearing of some cases where I think the definition of reasonably foreseeable has been stretched to its absolute maximum of someone's imagination, I think it is incumbent upon us to provide some degree of certainty over what we mean as a parliament, what we mean as legislators when we say reasonably foreseeable. And this particular amendment says that if the prognosis of 12 months or less remaining, I think this makes abundant sense. I want to thank the member for bringing it forward. And there's people that are watching, of course, committee deliberations. I haven't made any secret that I think there should have been more time to hear witness testimony. And I really think if we're honest with ourselves, what we heard around the table, what we heard from members of the disability community, I think it was an eye-opener for everybody. Whether we're willing to admit that or not, I think it was an eye-opener. I would have liked to have explored some of these issues further with them. We've been presented with a perspective that somehow in the physician community, there's overwhelming support for this bill. But then as we studied it, we realized, no, that's not the case. I mean, every one of us as committee members received a letter signed by 800 or 900 physicians. And that's a huge number. Like someone said, well, that's not as many as there is in all of Canada. Well, of course not. But if 900 physicians sign a letter, I as a member of parliament, I'm going to take notice of that. So based on the feedback that I've seen, I really think that we're helping, we're doing our job by being a bit more certain in what we mean. I mean, reasonable foreseeability, that kind of language is wide open. To the best extent possible, we should give certainty in our laws. If you're traveling down the highway and you see a sign and it says your speed is reasonable, what does that mean? Does that mean 70? Does it mean 90? Does it mean 130 kilometers an hour? I know for me, it might mean something that it means for you. Be reasonable. Well, officer, I was being reasonable. No, you weren't being reasonable. Who decides what's reasonably foreseeable? But if the speed limit, and I know I'm in New Brunswick, I recognize we're a big country, and we've had a big discussion on that this morning, how big the country is, covering many time zones. In New Brunswick, on most highways, it doesn't say be reasonable. It says 110 kilometers an hour. And that's so I know if I'm over that, I'm speeding. If I'm at 110 or under, I'm not speeding. And I think that makes sense. And I also think it makes sense for us to define in some way what reasonable foreseeability means. And that's why I'd like to speak in favor of this BQ 3. Thank you.
Thank you, Mr. Moore. Monsieur Thériault.
Yes, Madam Chair. I would like to thank my colleague, Mr. Moore, the Conservative colleague, to find this amendment interesting. It may not be for the same reasons that I have. Nonetheless, I would like to remind my colleagues that they were preparing to vote against this amendment. And if it could bring together the Conservatives and who may have a completely opposite position that they have been speaking of from the beginning, I think that we have here an interesting compromise and a consensus. All that it does, I would like to remind you that the bill sets aside, it takes away the criteria of natural death. This is no longer a criteria to have access, that it be for reasonably foreseeable a death. But however, to decide on the safeguard regime that is for the individual who is making a request for MAID, if as to whether not they are in a situation where they have a foreseeable death within the 12-month period, or once they're making the request, they're in a situation where they have 12 months and more, which would mean that they would have to follow the 90-day parameter, and 12 months or less, they do not necessarily have to do either the 10 days, or if they don't necessarily have to give final consent. So practically speaking, what that does in the field, it enables precision for practitioners, for the foreseeability, and in no way does it limit access to MAID. In no way. However, it does allow, because it's a medical notion, it allows things to be more precise, and I believe this brings clarity to the bill, and I hope I've convinced my colleagues.
Monsieur Thériault, I'll then call the question at this time. There's no more people on the speakers list. Go ahead, Mr. Clerk.
Mr. Cooper?
In support.
Ms. Finlay?
I support this amendment.
Monsieur Thériault?
For.
Opposed.
Mr. Calloway?
Against.
Mr. Lewis?
I support.
Mr. Maloney?
Against.
Mr. Moore?
Support the amendment.
Mr. Sangha?
I oppose.
Mr. Virani?
I oppose.
Mr. Zuberi?
I'm against the amendment.
So yeas pour 5-5, nays contre 6-6.
Thank you very much, Mr. Clerk. So the amendment is defeated. We'll now move on to CPC 2. Mr. Moore, if you'd like to move this amendment.
Thank you, Madam Chair. I'd like to move this amendment. What our amendment would do here in Bill in C14, it required 2 independent witnesses, and that was something that Parliament, in its wisdom, with a brand new regime of medically assisted dying, Parliament included that requirement. To me, when you're dealing literally with life and death, that requirement makes sense to me, that there would be the 2 independent witnesses. What C7 does is it removes the requirement for 2 independent witnesses. And, listening to stakeholder interventions on this bill, particularly the Canadian Society for Palliative Care. These Canadian Society for Palliative Care is representing the physicians and others that are dealing with people at end of life. And we hear a lot of talk about how, it's not a true decision if you don't have appropriate palliative care. And a lot of people pay lip service to palliative care. But any one of us, if it's someone that we know, is going to want them to have the best palliative care opportunities as possible at an end of life situation. And the Canadian Society for Palliative Care supports this amendment that would maintain the requirement for 2 independent witnesses. You can imagine with the different dynamics of how when we're talking about assisted dying, and we're talking about Bill C7, which dramatically changes the law in Canada when it comes to assisted dying. Because in fact, now someone doesn't have to be, as we would have thought before, at end of life. They may have a prognosis that says you have 30 years to live. You have 20 years to live. So in light of that expansion, I think it's important that we maintain safeguards that make sense. And to me, it makes abundant sense to have two independent witnesses, as the motion says, signed by the person or by another person under subsection 4 before two independent witnesses who then also sign and date the request. I can tell you, is someone who's dealt with legal matters before. I mean, you don't want to have one witness to something anyway. Having two witnesses, it eliminates any degree of uncertainty that could exist. There's always going to be challenges, but I think in Parliament's wisdom, under a Liberal majority government, when C-14 came forward, there was the requirement. This amendment is not earth-shattering. It is as modest as possible, and it's saying, you know what? Let's maintain that safeguard. That's what this was couched as. It's a safeguard. We've heard testimony. We're dealing with the most vulnerable in Canadian society. We're dealing with people that are in very difficult times. We're dealing with a literal life or death decision. So let's maintain this safeguard. That's why I'm moving this amendment, CPC 2.
Thank you very much,
Chair.
Mr. Moore. We'll go to Mr. Zuberi. Go ahead, sir.
So I'd like to speak to this suggested amendment, and out of full respect for what Mr. Moore had just proposed, and after careful consideration, I'll have to speak out against the amendment for the reason that I would appreciate if only these two individuals, these two witnesses, were the final deciders in terms of an acting made on the part of the individual. But we know that there are other procedures that must be followed. And we know that the witness, for example, does not assess eligibility of whether or not somebody is eligible for MAID. We also know that the witness doesn't establish whether or not there has been undue pressure or influence on the part of the person requesting MAID. Because there are other steps in the process, other people who actually go through this process, I have to speak out against this motion and say that we keep it as originally outlined. Thank you.
Thanks, Mr. Zuberi. I have Madame Finley next on the list.
Thank you, Madam Chair. I'm actually quite distressed about this issue, and I want to speak in support of the suggested amendment. And I appreciate MP Zuberi's thoughtful comments, but again, in a past life as a lawyer, I've had the opportunity to draft many a will. And when you are dealing with your assets, when you are a full and complete, you're sound of mind and body and have full cognitive abilities, and you draft a will, at least in British Columbia, you have to have that will witnessed by two independent witnesses, not mentioned in the will. They don't have to read what's in the will. In fact, they don't need to do that at all, but they need to be present, and they need to both sign that establishes the authenticity of the signature and the intention of the testator. It seems to me that if we have those safeguards in place legally, when someone anticipating death is dealing with their assets, we should at a minimum have the same requirement for someone anticipating ending their life. It seems to me one's life is a lot more important than one's assets. And yet we seem to be just throwing away that sort of, again, another safeguard, even though it may not even be the biggest one we're throwing away here with this new legislation, but it's an important one that establishes that the person who is making this decision is signing on to it and requesting it with to support, again, that intention and that authenticity. I just can't imagine how we would place in law a higher onus and a more careful environment for one's assets than one's life. And I would urge members of the committee to reconsider on this one. It's not a big amendment, it's a small one, but it's a very important one. And I ask you to really think on that.
Thank you, Madam Finley. I have Mr. Cooper next on my list. Go ahead, Mr. Cooper.
Thank you, Madam Chair, and I speak in support of this amendment. And I want to reiterate a point that Ms. Findlay made also as a lawyer, that in order to execute a valid will, 2 witnesses are required. And here we're talking about the most significant procedure that could be undertaken in someone's life, namely to end their life. And the safeguard required would be less than that which is required to execute a valid will. Now, I can say that when Bill C-14 was debated, that there was widespread consensus around the need for there to be 2 witnesses. Not only 2 witnesses, but 2 independent witnesses. The legislation that the government has put forward not only removes the very common sense requirement that there be 2 witnesses, but it goes further than that and removes the requirement that there be independent witnesses. Indeed, under Bill C-7, someone attending to a patient's health could provide could be a witness, and that obviously raises concerns around conflict of interest, around coercion, subtle coercion, unintended coercion, having regard for the power imbalance that exists between, for example, a medical health professional and a patient, particularly vulnerable persons. And the evidence that we heard at committee in the very limited hearings that we held on this bill was overwhelming in terms of support for maintaining this safeguard, including the Canadian Palliative Care Association, among other witnesses. I have not seen any convincing evidence to demonstrate that the witness requirement in any significant way impedes access to physician-assisted dying. And so on that basis, I believe that this is an important safeguard to protect vulnerable persons, and that was backed up by the evidence. And on that basis, I hope that this committee sees fit to pass this amendment. Thank you, Madam Chair.
Thank you, Mr. Cooper. We'll go to Mr. Lewis next, and then Mr. Garrison. Go ahead, Mr. Lewis.
Thank you, Madam Chair, for the opportunity to speak to this amendment. I think it's a very important amendment. Madam Chair, in my personal life, when I bought a car, when I bought a house, I had to get co-signers sometimes. In my business, in the world of business where I come from, I had to get co-signers. And I guess why I even question why we're even discussing this is what I just spoke to is purely monetary. Now we're talking about someone's life, the very breath that they breathe. And to suggest for a moment that there shouldn't at least be 2 witnesses. 2 witnesses is all we're asking for. But to force other people to have co-signers and witnesses on something monetary, such as a house or a business or a car, I think is totally backwards thinking on this. Now, Madam Chair, this has been in the legislation. I guess I have to question now, what exactly is the long-term goal of not keeping 2 witnesses? Is it so that eventually we'll have 0 witnesses? Certainly that's not what the government is thinking when in the proposed legislation. Certainly there's nothing wrong with having 2 witnesses. This amendment is absolutely vital. And again, I go back to, this is not a monetary discussion. This is the lifeblood of someone. I can't conceive why anyone would not suggest for a moment that someone's life is not as important as 2 witnesses. Madam Chair, I'm going to be voting very much in favor of this amendment, and I would totally respectfully ask everybody to really consider, really pay attention and consider this amendment. I'll be voting in favor. Thank you, Madam Chair.
Thank you. Mr. Garrison, please go ahead.
Thank you very much, Madam Chair. I'd just like to draw members of the committee's attention to the brief that was submitted by the Association of MAID Assessors and Providers. They've talked about the real life experience of applying MAID. And what they found was that in certain circumstances, sometimes, especially in rural and remote communities, the requirement of having 2 independent witnesses raised privacy concerns and raised concerns about involving people from outside the narrow circle around the patient who was requesting medical assistance in dying. And their opinion was that because the function of witnesses is not to assess, but simply to verify identity, that there was very little added in terms of protection by having a second witness. So I think that we should listen to those when it comes to this narrow question of what might constitute an obstacle or what might inflict privacy concerns on those requesting medical assistance in dying. And that is the testimony that we received from MAID assessors and providers. So I will be supporting this amendment. Thank you.
Thank you, Mr. Garrison. Madam Finley, did you have something to add?
Yes, I do. I understand that it may be inconvenient for assessors and suppliers. It's inconvenient when drafting a will and drafting some other legal documents sometimes to have a second witness. But people know that's the legal requirement, and it always happens. And people in remote communities draft wills. In fact, the very people who might be asking for MAID in a remote community would probably have drafted a will before they decided to do it. I can't imagine if you put into the ending of your life the forethought that it would take to seek medically assisted death, that you wouldn't probably also deal with your assets. So the very people we're talking about would have normally drafted a will, had 2 independent witnesses to the authenticity and intention. They would be independent, meaning they would not be necessarily drawn in at all to your confidences on your decision. But you actually would have had to go find those 2 independent witnesses to deal with your assets, no matter where you live. And yet we're saying you don't have to do it to end your life. So I don't accept that. And I think if one gives it some careful thought, it doesn't actually make sense given the other legal requirements we have in life.
Thank you, Madam Finley. We'll go to Mr. Cooper next.
Actually, I'm okay.
Okay, so we'll call the question at this time for CPC 2. Should CPC 2 carry? Mr. Clerk, if you can please administer the vote.
Yeah, let's find out, Madam Chair. Mr. Cooper.
In support.
Ms. Findlay.
In support.
Monsieur Thériault.
Mr. Thériault. Against.
Mr. Garrison.
Against.
Mr. Kellaway.
Against.
Mr. Lewis.
I vote in support.
Mr. Maloney.
Against.
Mr. Moore.
Support.
Mr. Sangha.
Against.
Mr. Virani.
I vote against.
And Mr. Zuberi.
Against.
So, yeas pour 4, 4, nays contre 7, 7.
So the amendment is defeated. We'll now go on to CPC 3. Mr. Moore, if you'd like to move that.
Thank you, Madam Chair, and I so move. What CPC 3 would do is in C7, there's, as we discussed, there's two tracks where death is reasonably foreseeable and where death is not reasonably foreseeable. The government has introduced on the track where death is not reasonably foreseeable a requirement that the physician have expertise in the patient's ailment, that one of the physicians. And what this amendment would do is that it would require and would apply that same criteria, which I think is a smart criteria, that it would apply to the criteria that one of the physicians signing off has expertise in the patient's ailment to all cases of assisted dying, not just where death is not reasonably foreseeable. So where death is reasonably foreseeable, because as mentioned, and we just had this debate, reasonable foreseeability is not defined. I thought we should have defined it a few minutes ago with the BQ amendment that would define it at 12 months. We chose not to do that. So in light of that, and in light of the fact that the government did see fit to include it for the track where a death is not reasonably foreseeable, I think there's merit in that, and I think it should apply as well where death is reasonably foreseeable, and that's why we've moved this amendment. Again, we heard, we didn't pull this amendment out of thin air, partially based on what the government has done on the new track where death is not reasonably foreseeable, but also due to testimony. We heard very compelling testimony, both from physicians, from specialists, as well as persons with disability, about the importance of having someone that knows what they're talking about with someone's condition. And we're going to get to other prospective amendments later, but we've heard about the amount of time it takes someone to get in to see a specialist, to begin treatment, to have treatment take effect. If someone has had a diagnosis of a very serious ailment or a very serious injury, that oftentimes there's ups and downs in their thinking about their future, but also, the prognosis. So ensuring that one of the physicians that's dealing with this patient has a specialty in the condition that the patient has, I think it's a good safeguard that the government has introduced on the track of not reasonably foreseeable. I think it should apply where death is reasonably foreseeable as well, and that's why we've moved this amendment. Thank you, Madam Chair.
Thank you, Mr. Moore. Mr. Virani, you're next. Go ahead, sir.
Thank you very much, Madam Chair. In terms of this sort of track, the notion of track one and injecting the expert requirement into track one, what we have is a situation around the country where healthcare providers have been exercising a great deal of judgment in delivering MAID. That's certainly what we heard in the consultations that took place in January and February. In cases where the medical team surrounding a patient doesn't have the necessary expertise in the patient's condition to do a comprehensive assessment, providers are already consulting experts as part of good medical practice. And we believe that they will continue to do so. And what we've done here is reduced the barriers to accessing MAID for people who are reasonably foreseeable, but enhanced safeguards for those who are on track two, because by definition, their death is not as imminent or as foreseeable. Adding an additional issue of attaching an expert requirement here for the group that is in track one would not enhance safeguards, because the safeguards are already doing the work they need to do, but would in fact act as a new barrier for access. So on that basis, I will be opposing this amendment. Thank you.
Thank you, Mr. Virani. Mr. Lewis?
Thank you, Madam Chair. I have to simplify things sometimes, and I know when I got shoulder surgery there to repair my broken shoulder, some 3 or 4 years ago, the first thing I did was went to my general practitioner, and he didn't say that he was going to do the surgery. No, he sent me to a specialist. So when I think about this, again, we're getting back to, for me, it's very black and white. So if we're talking about life and death, I don't know why there's even discussion around this table with regard to having a specialist, ensuring that there's a specialist there to say, yes, this indeed is the ailment, and indeed this person should have made. Because again, my general practitioner, he didn't do the orthoscopic surgery for my shoulder. He sent me to a specialist. Now, notwithstanding that, Madam Chair, if I went to that specialist, I could also get a second opinion. So my point is, in death, why would we ever put this weight on a practitioner and not have a second opinion? I mean, this to me is A, giving protection to our practitioners, but B, giving the real life story for the person that may or may not need MAID. Because if I don't know what I'm talking about as a practitioner, I certainly don't want to be the one that says administer MAID. If it's not my specialty, why would I do that? So, Madam Chair, this is a very, very important amendment, and I will be supporting. Thank you.
Thanks, Mr. Lewis. Monsieur Thériault, I see you next on the list. Go ahead, sir.
Thank you. I think that my conservative colleagues are forgetting a few things. Here we're talking about people whose death is foreseeable. And sometimes we're talking about just several days. We're talking about a terminal phase. And a patient, when we say that the patient is the standard, we need to understand what is coming from the patient's condition. And a generalist, a medical doctor who is practicing, is able to read the patient's file as a whole, and a patient who would come to an emergency and who is in a terminal phase of life, and to see that he has several hours, the patient, or maybe at the most just several days left. So why would we need to bring in a specialist when it's a generalized cancer? We don't need an orthopedist. So what do we need when you have your kidneys that aren't working? Do you need a kidney specialist? We're talking about the general condition of the patient. That means that they're in the terminal phase of life and that they're suffering. And if they're asking for MAID, it's also not only because they want to end their suffering, but there are criteria to apply for them to have access. So I don't see what the competency of a doctor within a given part of the medical system will add, and where it will add anything more otherwise, other than to have further delay for somebody who is already in the process of dying and has been in the process of dying for quite a long time, and where the situation is irreversible. And for the person who wants to end their life at the end of this process, it's possible for them to do so. They don't need to make a request. But for the one that does need to make a request, I think that honestly we need to come back to the meaning of what it means that the patient is at the heart of this. You don't need a specialist from every organ in the body to be able to take into consideration the terminal phase of a given patient. Thank you.
Thank you, Monsieur Thériault. Madame Finley, I have you next on the list. Go ahead.
Thank you, Madam Chair. I'm finding some distress here when we're discussing these things. There's a lot of assumptions being made within these discussions about patients' conditions, about what a medical practitioner may or may not do. from a lot of us who frankly aren't doctors. We've heard a lot of testimony. I would have liked to have heard a lot more testimony, but we've heard testimony before this committee that says some of that testimony quite contrary to a lot of assumptions being made here about capacity, about who is signing off on this. I mean, we're legislators. We're not medical practitioners, and it's our job to try and have at least some safeguards on a legislation that is literally about life and death. And one size fits all is not a good public policy, in my view. We have to be aware that there are differences, there are regional differences, there are patient-centered differences, and having one of the physicians signing off with an expertise in that patient's ailment seems to me to be the kind of minimum criteria I would want for any procedure relating to my health of any serious nature. I don't see that that is overly onerous, but it is a safeguard, again, to just make sure that everything is as it should be and that it's understood at the time that a big decision like this is being made. There seems to be an assumption in the discussions here that it's sort of just an inevitable thing, and it should be a clear choice right up to the end of life that what you're doing is your clear choice, and it is for valid reasons. And I don't see this, again, we seem to be in the legislation as presented, throwing out so many safeguards way outside the Truchon decision without the careful thought put into it that some of these safeguards would just allow for. Thank you.
Thank you, Madam Findlay. And then Mr. Moore, if you wanted to make your closing remarks then on what you've heard.
Sure. Yes, I hadn't planned to actually speak again, but Mr. Theriault made some points that I don't think are on point with what's being proposed here. He mentions a scenario where someone has hours to live or weeks to live. Just by the discussion around his own amendment around reasonable foreseeability of death, we already know that under the previous C14, individuals with a prognosis of living for well over a year have received assisted dying. So we're not being overly prescriptive here, but we have to recognize that some of the individuals that may, depending on the assessment, fall under reasonable foreseeability of death may still have quite a bit of time to live naturally. And what we're saying is, in the wisdom of what the government has put in place under individuals whose death is not reasonably foreseeable, there's going to be people fall in the margins on both sides of that issue, and of that line, that ill-defined line, a line that we've chosen today not to even attempt to define what reasonable foreseeability is. So in light of that, I think it's abundantly clear that the consultation with a physician, that one of the physicians should have an expertise in the person's ailment, whatever that ailment is. We're asking that one physician have that consultation with the patient. So this is not about people who have days to live. This is about people who could have years to live. And this requirement it has been adopted by the government on their other track. And I think, based on the testimony that we've heard, it's really abundantly clear that it's important and relevant for those throughout the MAID regime, not just on one track, but throughout, that they should be a requirement. They have a consultation with a physician who knows something about their ailment. The risk otherwise is just too great, in my view, to abuse of this system. But I'll leave it at that, and thanks everyone for their consideration of the amendment.
Thank you. I'll call the question at this time then for CPC 3.
Monsieur Thériault? No?
Sorry, Mr. Thériault
Miss,
that I saw? No?
Okay.
Okay, that's fine.
Mr. Cooper?
In support.
Oui, Madame la Présidente. Oui, Madame la.
yes, Madam Chair, I wanted to say it's always a specialist who will tell his patient that he can no longer do anything for him and that he is now beginning his palliative care phase.
We've started the vote already, so we'll continue with that if that's okay.
Madame la Présidente, j'entends pas ce que vous dites.
I'm sorry, I'm not hearing what you're saying.
Can you hear me now?
Oui.
Thank you. So we're just going to continue with the vote, which was already started before you started speaking,
d'accord.
sir. Sorry. Go ahead, sir. Go ahead, Mr. Clerk.
Okay, so we had already Mr. Cooper in favor. Ms. Finley?
I'm in support.
Monsieur Thériault?
Mr. Thériault? I'm against.
Against.
Mr. Calloway?
Against.
Mr. Lewis?
I'm in support.
Mr. Maloney?
Against.
Mr. Moore?
Support.
Mr. Sangha?
I'm against.
Mr. Virani?
Against.
Mr. Zuberi?
Contre.
I had a moment of distraction for Mr. Garrison. It was in the favor, right?
Against.
Yes, okay, thank you. Okay, so yeas pour 4, 4, and nays contre 7, 7.
Thank you, Mr. Clerk. So CPC 3 is defeated. Now going on to CPC 4. Just a note that if CPC 4 is adopted, it makes CPC 5 unmovable because of a conflict of lines. So Mr. Moore, if you'd like to go ahead and move CPC 4 or 5, go ahead.
Thank you, Madam Chair, and I'd like to first move CPC 4. CPC 4, again, reflecting back on Bill C-14, which was just adopted 5 years ago. C-14 required that someone be given the opportunity to change their mind after requesting made. We have to remember that we're dealing with people, this is again where death is reasonably foreseeable, but it doesn't mean it's imminent. It doesn't mean it's within weeks. It could be, in fact, as we've seen from some cases, it could be years. So what it does, and we heard testimony after testimony, the limited testimony we've had, it became a theme that people can change their mind. And we toss around this idea of life or death. You know, people have said this is a life or death situation when often it isn't. But in this case, we are literally dealing with life or death. Now, the majority Liberal government that introduced Bill C-14 put in place a requirement that there be 10 clear days between the day on which the request was signed or on or before or behalf of the person and the day on which the medical assistance in dying is provided. So it means that if you've signed and you said, I would like to have medical assistance in death, that there be 10 clear days. And there was a reason why that was put in place by the Liberal government. Provided, or if they and the other medical practitioner or nurse practitioner referred to in paragraph E are both of the opinion that the person's death or loss of their capacity to provide informed consent is imminent, any shorter period that the first medical practitioner or nurse practitioner considers appropriate in the circumstances. So I've heard from other colleagues when we've discussed this that say, hey, sometimes this is just making people wait for no reason. Well, the legislation, C-14, provided for that scenario. The 10 days could be waived in circumstances where death is imminent. If someone was going to pass away in 2 days or a day, no, there did not have to be a 10-day reflection period. But remember, we're dealing with cases sometimes where an individual may have years to live. And what we're saying is take that 10-day reflection period. There's a reason it was put in place. So this would ensure, as you all know, that now we have 2 tracks, death reasonably foreseeable and death not reasonably foreseeable, without a definition of what reasonably foreseeable is. If someone falls into the other track, there is a 90-day reflection period. If someone falls into death being reasonably foreseeable under C-14, there was a 10-day reflection period that could be waived. C-7 strips that out. And I know what some might say, hey, it's unnecessary suffering and so on. But what they don't say is it could be waived. The 10-day could be waived. And I just want to list just a few organizations, and every one of us is familiar with these organizations. The Canadian Society for Palliative Care, the Council of Canadians with Disabilities, Inclusion Canada. We heard testimony from their executive vice president. The persons with disabilities communities are in favor of this being reinstated. Palliative care physicians, these are end-of-life physicians, are in favor of this being reinstated. So all I'm asking, we're not asking for anything earth-shattering here. Some of the safeguards that were put in place by the government previous were just that. They were safeguards to protect the vulnerable. One of them was this 10-day reflection period. C-7 takes it out. This amendment simply keeps it in. And it keeps in the possibility that the 10 days be waived where death is imminent. So I thank you for your consideration of this amendment.
Thank you, Mr. Moore. Monsieur Theriault, I have you next on the list. Go ahead, sir.
Yes, Madam Chair. I simply wanted to underline that C-7, what it brings with respect to terminal patients where the death process is already underway and the death is inevitable, resides in the fact that we don't want to let somebody suffer for 10 days simply because we're not sure of what they desire. Once their intention has been clearly established, we should not let someone suffer. And for people who are in the field, sometimes one might think that the person may be able to live for those 10 days, but it might be delirium and extreme suffering and conditions that no one here would want to see someone near them go through. So it's not a question of reflection, it's a question of suffering that we'll be taking away for the patient. Thank you.
Monsieur Theriault, I have Mr. Maloney next on the list. Go ahead, sir.
I think I heard you call my name, Madam Chair. Thank you. I'm going to be brief and right to the point. Mr. Moore anticipated some of what I was going to say. Look, the preponderance of evidence that was heard during the course of the consultations makes it very clear that eliminating the 10-day reflection period is a critical thing to do. I think we need to listen to those people, and I therefore am not going to support the amendment. Thank you.
Thanks, Mr. Maloney. Mr. Garrison, I have you next, sir.
Thank you, Madam Chair. I think this amendment ignores an important fact here, and that is that those who have reached this point in their life where their medical condition has dealt them a bad hand, we might say, and who are suffering intolerably, have been consulting with their doctors, some for many months. This is not something that happens in any rapid fashion. And when we heard again from the assessors and providers who've carefully monitored what's happened under C14, what they very clearly told us was that this does inflict unnecessary suffering. And that, in fact, when you look at the statistics about the 10-day waiting period, that a very large proportion, over half of the medical students dying occurs on the 11th day. And that tells me that we are forcing people to wait and forcing them to suffer in a way that's not necessary if we are truly compassionate. So I will be opposing this amendment. Thank you.
Thank you, Mr. Garrison. I have Mr. Cooper next on the list. Go ahead, sir.
Thank you, Madam Chair, and I support this amendment. The Supreme Court of Canada in the Carter decision contemplated a carefully designed and monitored system of safeguards. And Bill C7 removes one of the key safeguards provided for in Bill C14, Parliament's response to the Carter decision, and that is a reflection period. If you look at the legislation as it is currently drafted, it could provide a scenario where there is same-day death, where there is virtually no reflection. And it is important to note that people do change their minds. Indeed, in the Truchon decision, evidence before the Quebec Superior Court indicated that in the province of Quebec, between December of 2015 and March of 2018, some 167 written requests were subsequently withdrawn by patients because they had changed their mind. That equals to approximately 7% of all made requests in the province of Quebec. This data, I believe, underscores the need for a reflection period. And with the issue surrounding the loss of capacity, that is already addressed in the existing legislation in C14, whereby that period can be shortened where necessary, but that should be limited. It should be the exception. It should not be the rule. Thank you, Madam Chair.
Thank you, Mr. Cooper. I have Mr. Lewis next on the list. Go ahead, sir.
Thank you, Madam Chair. And just a couple of very brief comments. The first one is, I was a firefighter, first responder for 7.5 years. So, of course, I went to a lot of car accidents and I went to a lot of fires, but I equally was a paramedic as well, and responded to a lot of folks that had DNR orders. And at the time, the fire department that I was part of, we didn't recognize a DNR order, so we would send them to the hospital. And I will tell you, in my 7.5 years, on more than one occasion, in the small town that I was a firefighter in, did I meet somebody on the street, a cancer survivor, that in going to the hospital, they actually found a new specialist, a new treatment, and they indeed survived. My point is this. I think we'd all agree that if something upsets us, we at the very least have what I call the 24-hour rule. This is now somebody's life. And I think that a life deserves, at the very least, a 10-day reflection period. And again, I go back to my time served on the fire department in that I've seen this. I've been part of it. I've seen people that are in a coma that the doctors have said, pull the plug. And 18 days later, they wake up with a thumb up. And they're now living a normal life today. So because I've seen it, because it's firsthand for me, I really don't understand why we would not have that 10-day reflection period, at the very least, to talk it through. I think it's absolutely vital. And I guess that the last point I would make to this is, this was the Liberals' legislation through C14. And I suppose if they don't believe now that we need a 10-day reflection period, are they suggesting that they were wrong when they put this legislation forward in the first place? Thank you, Madam Chair.
Thank you, Mr. Lewis. Madam Finley, I have you next. Go ahead, ma'am.
Thank you, Madam Chair. Speaking in support of this motion, and listening to the discussion we've had to date, obviously we've had a breadth of witnesses, and it seems very clear at this point that certain members of the committee are listening to certain witnesses and others are listening to other witnesses. And I guess it depends where you're coming from, who you want to give emphasis to. But the whole point of having a variety of witnesses is that you hear more than one point of view, and you hear, and we have heard more than one point of view from persons with disabilities who spoke very, I felt, in a very heartfelt and personal way about their personal experiences, and also from physicians and family practitioners and those even academics who have a variety of opinions. The whole point of having a reflection period, as was in the original legislation, is because it is patient-centered. I'm hearing comments here that, everyone at that point is sure of what they're doing. With respect, I don't see how that's necessarily possible when we've also heard testimony about transient suicidal ideation, about people who do change their minds. My colleague, MP Cooper, spoke about the Quebec example, but the number he had only went to March of 2018. The further report that we have that comes right up to date from Quebec's annual end-of-life care report said that since 2015, over 300 patients in Quebec alone changed their mind after requesting medical assistance in dying. There's already exceptions existing under the original law for those whose death is fast approaching, and for people who will soon lose the capacity required to provide the necessary informed consent. So they're already contemplated. And this 10-day reflection period gives the patient the opportunity, not the doctors, not the nurse practitioners, not the people around them, not their family. It gives the patient the ability to change their mind. And we should give them that autonomy. We've talked a lot here about autonomy. We've talked a lot here about a patient focus. This is what this is meant to do. If there's 300 people in Quebec alone who have changed their minds, and I wish I had a national statistic, they're hard to find, but there are 10 provinces in Canada, and that means there's probably thousands of Canadians who have changed their minds. They should have the ability to do that, and that's what this is speaking to. Thank you.
Thank you, Madam Finley. Mr. Cooper, I have you next.
Thank you, Madam Chair. And I would just like to add that providing for same-day death or entertaining that possibility, as Bill C-7 would allow for, I believe is virtually unprecedented in any other jurisdiction. I recall that when we considered the reflection period during the debate around Bill C-14, that at the time we were looking at a 14 or 15-day reflection period. The government brought forward an amendment to reduce that to 10 days, and even a 14 or 15-day period, as I recall, was significantly less than that which was provided for in the Benelux countries, where the waiting period, at least as of 2016, was in the range of 30 days. So we really are heading down uncharted waters. And I think any time that we legislate on this issue, in which there are so many complexities, when we're dealing with vulnerable persons who are at their most vulnerable state in life, in many instances, that we proceed with care and caution and having regard for the evidence before our committee, having regard for the data coming out of the province of Quebec. I believe it is imperative that we maintain a reflection period and not go down an uncharted path. Thank you.
Thanks, Mr. Cooper. I have Mr. Moore next for anything to add to what you've already spoken about. Thank you, sir.
Thank you, Madam Chair. And a couple of my points were made by others, and I promise I won't remake them. But I do want to respond to MP Garrison mentioned that assessors and providers of MAID are in favor of waiving the 10-day reflection period. There was consultation that went into Bill C-14. We were supposed to have a parliamentary legislative review this past summer that would look back on what the Canadian experience has been dealing with assisted dying. But Parliament, based on consultation on C-14, put in, and based on international norms, put in a 10-day reflection period, a 10-day reflection period that could be waived when appropriate. Now, the Liberal government has put in a 90-day reflection period when death is not reasonably foreseeable, and we'll get to that later. But this 10-day reflection period is important. Mr. Garrison mentioned individuals who on the 11th day receive MAID. Well, that's not taking into account the people that within that reflection period decide not to go through with MAID. As Mr. Cooper pointed out, this happens. And we have to give people that opportunity. If we believe that, that life is important and every life is important, and as we heard from individuals in the persons with disabilities community, I felt the value of their lives as they presented at our committee. Their perspective is important. Their life is important. And we know overwhelmingly that people can and do change their mind about assisted death. It happens. We also know this has been characterized as people who have days or weeks to live or hours. That is not what this is about. This is about, in some cases, people that could have years to live. So the least we can do as a safeguard, we're putting in place this regime. Everywhere else has safeguards. We need to have safeguards. This was a safeguard that was seen as appropriate just a few years ago. This is not something new. This is something that existed in the previous legislation, and we want to make sure we maintain that. And, we can talk about assessors and providers of MAID. Well, I'm also talking about the Council of Canadians with Disabilities. I'm talking about the Canadian Society of Palliative Care Physicians. These are physicians that deal day in and day out with end-of-life issues. Those physicians are saying, maintain this 10-day reflection period. I don't know how we as a committee can just ignore that and just cherry pick the odd thing that we agree with from people who have a completely different perspective, being the assessors and providers of MAID. Maybe the assessors and providers of MAID should not be the ultimate authority on all things dealing with MAID, including the safeguards and the 10-day reflection period. So we need to have a balanced approach. And a balanced approach, we've listened to the assessors and providers. I also want to listen to people with disabilities. I want to listen to other specialists. I want to listen to palliative care physicians. We cannot make this a closed club where the only people we listen to are the ones that provide MAID. That is not how this does work, and it's not how it should work. So with that, I'll leave it at that, Madam Chair, and thank everyone for their contribution to the discussion on this amendment.
Thank you, Mr. Moore. Mr. Cooper?
Very briefly, Madam Chair, I just wish to read into the record the words of Cardinal Thomas Collins in the Toronto Star on March 2nd, 2020, in regards to the reflection period. He stated, quote...
Madam Speaker, just on a point of order, Madam Speaker, unless this arises in response to something that was previously raised, perhaps it's not appropriate as a
well,
sort of
I think it is appropriate.
Mr. Cooper had an opportunity to raise his commentary.
Thank you, Mr. Virani. I'm going to allow Mr. Cooper to read this into the record right before we go into the vote.
Thank you, Madam Chair. I'll be very brief. Cardinal Collins states, quote, "In Ontario, we allow cooling off periods for gym memberships and new condominium purchases, but the federal government doesn't seem to believe a similar reflection period is necessary for euthanasia," close quote. I think those are prescient words. Thank you, Madam Chair.
Thank you, Mr. Cooper. We'll go to a vote on CPC 4 at this time. Mr. Clerk?
Mr. Cooper?
In support.
Ms. Finlay?
I support this amendment wholeheartedly.
Monsieur Thériault?
Mr. Thériault? Mr. Thériault? No.
Against.
Mr. Kellaway?
Against.
Mr. Lewis?
Strongly support.
Mr. Maloney?
Against.
Mr. Moore?
Support.
Mr. Sangha?
Against.
Mr. Virani?
Against.
And Mr. Zuberi?
Against.
So, Madam Chair, yeas pour 4, and nays contre 7.
Thank you, Mr. Clerk. So CPC 4 is defeated. We'll go to CPC 5 now. Mr. Moore, if you'd like to move that.
Sure, I would like to move CPC 5. Just ironic to see members just now having voted against the very safeguards that some of them voted for a few years ago. I'm just profoundly impacted by that. But anyway, in light of that decision by the committee to not have the 10-day reflection period any further, CPC Amendment 5 would amend Bill C7 to include a 7-day reflection period. Now, recognizing, as has been said by some members, that they feel the 10-day reflection period is perhaps too much, in spite of the fact that the 10-day reflection period could be waived, this would insert a 7-day reflection period also with this, under the same proviso that it could be waived. The 7-day reflection period, having a reflection period, as I mentioned previously, is supported by the Canadian Society of Palliative Care Physicians, supported by witnesses that appeared before this committee, supported by the Council of Canadians with Disabilities. They support having a reflection period. Other jurisdictions have a reflection period. Up until apparently just now, the Liberal government supported having a reflection period based on consultations that they said that they did on this legislation. So the idea that there be a reflection period in a life or death decision is abundantly clear to me that there should be one. It's apparent from the vote that we just had that the majority of members feel that the 10-day reflection period is too much. That's the 10-day reflection period that existed before, and that, as I mentioned, can be waived. So in an effort to have some kind of reflection period, recognizing the fact that Mr. Cooper raised in his remarks that Canadians eligible for MAID have said that they want to receive assisted dying. And then subsequent to that, during a period of reflection, have decided not to proceed. literally life or death decision. Recognizing that fact, it's incumbent upon us to provide some measure of reflection. In cases where someone's death is imminent, this can be waived. But this says that due to the enormity of the decision being made, that there be a period of reflection. And if committee members feel that 10 days, as has existed for the last 5 years, if they feel that is too much, then we are proposing that we have a reflection period of 7 days. And I think that's the least that we can do. So I thank members for their consideration of CPC Amendment number 5, which would provide a 7-day reflection period before accessing MAID. Thank you.
Thank you, Mr. Moore. Just going down the speakers list at this time, Madam Findlay, you're up next. Go ahead.
Thank you, Madam Chair. I'm speaking in support. Obviously, I was in support of the longer reflection period, but I am very much in support of a reflection period. This is what this is all about. This is what we've had testimony about how important it is. It also, to me, underscores the problems with creating a new legislation without having had the proper reviews of the operation of the first legislation that was passed just a few years ago. It is my understanding that to date, no provincial or territorial government has released into the public domain a comprehensive report on the performance of its MAID program that would include the perspective, other than what I've already cited in Quebec, of the numbers of people who've changed their minds. It's good that at least Quebec and Ontario have released some partial information. So here we are debating a huge change in legislation, a removal of a very essential reflection period, which is patient-focused, where we haven't even had the benefit of reviews on how the MAID program that's already there has rolled out province to province. We're operating in the dark, and as with all due respect to those practitioners practicing MAID, the MAID suppliers or providers, if you will, they're a very, very small percentage of the medical profession. When we had contrary views put before the committee, a letter of 800, I think it's up to 900 physicians, one of the witnesses, Dr. Nod, just said, that's a minor percentage, it's no big deal. Well, the number of people who actually practice and supply MAID is a smaller number than that in Canada. So we're listening here to a very small group of practitioners when you look at the overall number of physicians and nurse practitioners and healthcare providers in Canada, and changing a system for all Canadians, once again, based on one province's court decision, which in itself did not go as far as we are going in these changes. And if we truly care about what each patient is going through, if we truly care about what each patient is thinking within themselves as they make these decisions, and if we truly believe in their autonomy, we should give them the ability to change their mind. As I pointed out, that at least 300 Quebecers that we know of did over a few year period, and as reported by the health authorities in that province. That is where compassion should lie, with the patients, with the people struggling. I've heard a lot of opinions here around this table. Oh, by the time you get to that point, you're all decided, it's all done, it's not, like, just don't get in the way. That is not the true patient experience. We're hearing very much to the contrary, and we've heard that testimony. And again, one size does not fit all. We should not be that tied to a certain ideology here that we forget about each and every patient struggling with a life and death decision. Thank you.
Thank you, Madam Finley. And just before I go to Mr. Maloney, I want to welcome MP Jansen, who is joining us to replace Mr. Lewis for a little while. Thank you for being with us. Mr. Maloney, go ahead, sir.
Thank you, Madam Chair. I'll be very brief. Look, I have a great deal of respect for the opinions of Ms. Finley and Mr. Moore and everybody on this committee and everybody who's feels as passionate about this topic as those of us part of this meeting. But with respect, the discussion on this amendment is identical to the discussion we just had on the previous amendment. For that reason, I won't reiterate my points that I made earlier, and I'm hopeful that we can move forward and deal with this without rehashing all of the points, as passionate as they may be put forward. Thank you.
Point of order, Madam Chair.
Yes, Mr. Lewis?
Thank you, Madam Chair. Ms. Jansen is not replacing me.
Oh, my apologies. I must have been misinformed. Well, I'm glad that you're staying with us then, Mr. Lewis. Thank you.
Thank you.
Monsieur Theriault, you're next on my list. Go ahead, sir.
Yes, thank you, Madam Chair. I don't know what ideology Madam Finley is referring to. I would like her to name my ideology, if it's not the respect of the person. And I don't necessarily think that that's an ideology, but it's principles that are at the basis of our society of rule of law. When we believe in the respect of the dignity of the human being, we absolutely have to ensure that it is not simply a vision of the mind. We have to look towards the auto determination with respect to biomedical decisions. Nobody can attack the humanity of the person unless they have a free, and I insist on the word free and informed consent. And when the person does make a decision, in what should they be given even more time, are you saying? If people have changed their decision, that's their decision, but you shouldn't go on the other side of things. That is, people who don't want MAID to be happening within their institutions, within their hospitals. There are not a lot of practitioners of MAID, and somebody who's in terminal phase, somebody who is gone through a process sometimes of 20 years of fighting a cancer, who has for maybe 1 year been under palliative care, and they have been in palliative care. There is no cure for that person, and when they end up in the emergency room because their body is no longer functioning, well, that person, if for the 20 years it was clear what they wanted in their mind, and that's what they preferred, maybe when they come to optimum palliative care, they might change their mind, and nothing stops anybody to change their mind with these 7 days or the 14 days. But the courts have told us that C-14, the criminal code, it was in violation of the right to life of the person. So I think that we have to put things into perspective. And when I'm being quoted a cardinal, I do have much respect for religious authorities. But when we bring in a cardinal opinion, when we're going through a clause-by-clause reading, I think that we're moving on to the other side of thing. That is, the respect of the dignity of the person means that we have to treat the other as an end in itself and not as a means to apply an ideology, whether it's religious or not, or any authority other than their own. That is the authority of the dying person, no other authority other than that of the person who has an irreversible disease under intolerable suffering, and they are the one that has to decide on the threshold of their suffering, and that's what we're deciding on today. And everything that can facilitate moving towards the threshold of death without suffering. This is what we're looking towards. To presuppose that you would need even more time when somebody is in agony, I think that maybe people would rather die rather than be having them made, because there may be being an ideology is being sustained. But I think that my colleagues, conservative colleagues, should not make the only guiding principle of our deliberation today. They must remember it is the respect of the dignity of the person, and that goes through the principle of total respect for their autonomy. All of your rights guarantee you the autonomy of your person. So why should the state take that away, that principle, at a most intimate time in the life of a person? That is really the fundamental question here. And we're trying to facilitate things so that people do not suffer and that we respect their will. We have heard witnesses who came to tell us that practitioners and doctors who give palliative care came to see if that they knew better than the patient what would be the best for the patient and the good of the patient. And they were trying to get them to change their mind because the patient didn't get a proper evaluation of themselves and that they had to die at the end of their suffering. Well, I don't think that that's quite a type of medical practice that we'd want to promote. But if somebody does want to continue to suffer, I would give them assistance till the end of their suffering because it's their decision. But in no way does this bill stop anyone from dying at the end of their suffering, in no fashion at all.
Monsieur Thériault, I have Mr. Lewis next on the speaking list. Go ahead, sir.
Thank you, Madam Chair. Sometimes less is more, so I'm going to be brief here. I just want to make one comment about MP Finley. And when she was speaking about the 300 people from Quebec, and I very much appreciate that and respect it. And I think at the end of the day, if we can talk about just one life, if one person had a reflection period and they went on to live, I think that can be the real narrative. So although I appreciate Mr. Thériault, his opinion on this, I think we're being incredibly fair. I think we're being incredibly just. And I'll just leave it with this, because this kind of puts it all into perspective. And I hope it resonates with the committee. Mark Warawa didn't see a palliative care physician for 9 days. So we just lost the last amendment, which was 10 days. He was in the hospital for 9 days before he saw a palliative care physician. That would be 2 days later than the 7 days. So again, we have to look at both sides of the issue here, but I think this reflection period is absolutely necessary and vital, because there's still people falling through the cracks. Mr. Wawa is exactly a perfect case for this. And I think that's the real importance that we have. We have to ensure we have a reflection period. Thank you, Madam Chair.
Thanks for that, Mr. Lewis. Madam Finley, did you want to add to your earlier remarks as well?
Yes, I do, because I think that Deputy Thériault and I actually, we totally agree with each other, but we come to different conclusions. But, this amendment is speaking to the free and informed consent of the patient. This is, even if someone is clear in their mind for 20 years, it gives them the opportunity at the very end of the day to just think again. This amendment is fundamentally to support the authority of the dying person and their autonomy. This is totally patient focused. If the person wants to have a change of mind, a change of heart, which we now have statistics that bear out that this happens, it's up to them. If they have intolerable suffering, they wouldn't change their mind. If they have lost capacity and already made their intentions known, this wouldn't change anything. We're talking about giving people a few days if they wish to change their mind, that they have that ability to do so. And I really urge people to consider this. Thank you.
Thank you, Madam Finley. We'll go to Mr. Garrison next. Go ahead, sir.
Thank you very much, Madam Chair. This is essentially the same debate as the last amendment, but I do want to note that it is not just one witness we heard from who favored removing the waiting period. There were a number of witnesses, including the Quebec Association for the Right to Die with Dignity, who read the same report that is being cited by the Conservatives. And I would urge us to be careful about interpretations of that report, because I believe that report says what is certainly the case from those that I have consulted with, and that is that the changing of the mind does often occur, but almost always during their assessment period, not during the reflection period. And so because someone has requested medical assistance with dying, they do not always go forward with that, nor are they always approved for that. And of course, the main protection that we have here, and I do have to make reference to this, is the professionalism of physicians. And so it does concern me when we hear members of Parliament talking about same-day dying, because this is not something that is in any way permitted or allowed under the law or professional standards in Canada. It's simply an exaggeration used for political import. So again, same debate. I believe the effect of inserting this waiting period would be to unnecessarily prolong suffering for those who've already gone through a long process of reflection and consideration. Thank you.
Thanks, Mr. Garrison. I have Monsieur Thériault next on the speaking list. Go ahead, sir.
I wanted to underline what Mr. Garrison has said, and also to say that sometimes I hear within the discussion that it is not a question of life or death, but when we're in a terminal phase, it's a question of a process of dying, that because we are receiving palliative care, good palliative care, it also has the effect of slowing down the dying process. And there will be a dose in palliative care, a final dose, which will mean that because we want to control pain, that will mean that at a certain point the heart will stop, and because the person is not asking to be reanimated, that will not be done in a terminal phase. But to say that palliative care, it is as though we're not intervening. This is not a natural death. It's far from it. It's a question where the individual has to decide by themselves if they want to shorten this irreversible process of death. That's what we're speaking to here.
Thériault, I have Mr. Cooper for any concluding remarks, sir.
Yeah, I'll be brief, Madam Chair. With respect to the comments that Mr. Garrison made, I would simply note that those concerns are being raised by medical professionals, by physicians, with respect to the possibility of same-day death. So those aren't my words. Those are the words of esteemed physicians. And with respect to the need for some kind of reflection period, I would note that Dr. Harvey Chochinov of the University of Manitoba noted in his evidence that death wishes can be transient even over a period of 12 to 24 hours. So again, underscoring the need for some kind of reflection period. I would have liked to have seen a 10-day reflection period, but seeing that that was rejected, at the very least, we should provide for a 7-day period. Thank you.
Thanks, Mr. Cooper. At this time, we'll call the question on CPC 5. Mr. Clerk?
Yes, Madam Chair. Mr. Cooper?
In support.
Ms. Finlay?
I'm in support of the amendment.
Monsieur Thériault?
Mr. Thériault? Again.
Mr. Garrison?
Against.
Mr. Kellaway?
Against.
Mr. Lewis?
I am in support.
Mr. Maloney?
Against.
Mr. Moore?
Support.
Mr. Sangha?
Against.
Mr. Virani?
Against.
Et puis Monsieur Zuberi?
Against. Contre.
Alors, Madame la Présidente, yeas pour, 4, 4, et nays contre, 7, 7.
So the amendment is defeated at this time. We'll now move to NDP 2. Mr. Garrison, if you would like to move that amendment, go ahead, sir.
Madam Chair, I'm not sure I'm the only one. Perhaps it's my internet connection, but I'm having trouble with the audio cutting in and out from you.
Are you able to hear me properly there, Mr. Garrison?
So it just cut out again. I'm not sure. I'm assuming you've asked me to move the
I
motion.
did.
If you can hear me, I will proceed.
I did. I do hear you quite clearly and well. So as you move it, we'll just try to see if we can just confirm that our technical issues are resolved. But go ahead, Mr. Garrison.
Thank you, Madam Chair. So NDP 2 is in essence a technical or a housekeeping kind of amendment. It does not assert anything new into the bill. The bill includes a requirement for additional expertise to be consulted in track 2, and whether or not that is an essential safeguard, I don't wish to debate at this point, but it doesn't state clearly who needs to consult and with whom in this period. So my amendment is purely an attempt to clarify the language to make it clear that if the assessors do not have the expertise they need, that one of them needs to consult with someone who has that expertise. Now, I understand that my attempt to clarify the language can be further clarified, and I believe that government members may wish to substitute some additional language, but this is simply about making things clear in the responsibility to consult additional expertise. Thank you.
Thank you for that, Mr. Garrison. Mr. Virani, if you want to, I see your hand raised.
Yes, thank you very much, Madam Speaker. And I've had the occasion to speak with Mr. Garrison about this proposed amendment because I believe it derives from some of the evidence that we heard about accessibility of the track 2 in places where you're living in rural or more remote communities. So I think the intent is sound. We had to think about this sort of on our side of the house, and there's a few concerns that we identified, such as the notion of the term "a person who has that expertise." We would endeavor to have that person be named as a medical or nurse practitioner. And specifically just providing some clarity in that regard. And apropos of that, what I've suggested is some altered language, which I believe Mr. Garrison has seen and approves of. And I've sent that language in advance to the clerk. And I believe he is circulating it to everyone in the group. But what I can do is I can read sort of what we are suggesting to sort of get at what Mr. Garrison is suggesting. So this would be a friendly amendment to NDP 2. So the paragraph sub E would read, ensure that another medical practitioner or nurse practitioner has provided a written opinion confirming that the person meets all of the criteria set out in subsection 1, semicolon, and then there would be a new insertion of an E.1. So that would be a new subparagraph. If neither they nor the medical practitioner or nurse practitioner referred to in paragraph E has expertise in the condition that is causing the person suffering, they or the other medical practitioner or nurse practitioner consult with the medical practitioner or nurse practitioner with that expertise, or they consult and share the results of that consultation with the practitioner referred to in paragraph E. So that language is, I appreciate it's a bit wordy, but it has been sent to the clerk, and he has, I believe, circulated it to the members of the committee. So that would be the proposed friendly amendment to NDP 2. Thank you.
Thank you for that, Mr. Virani. Let me just confirm with Mr. Clerk if that has been circulated.
Unless it's currently sitting in my outbox, it should arrive like any second soon. Thank you.
you.
Can members confirm that they've received the written amendments? I see thumbs up from all members. Thank you. So I don't have anybody on the speakers list at this time. Mr. Garrison, do you accept these friendly amendments? Yes? So we'll call the vote then at this time. Go ahead, Mr. Clerk.
Against.
Sorry, Madam Chair, I'm trying
My
to.
headset is continually malfunctioning here. Yes, I do. I believe it achieves the same goal as my original amendment, but with even clearer language. Thank you.
Madam Speaker, there may be, the department officials have been patiently with us for over 2 hours now. Do they have any thoughts on what this amendment achieves? Just turning it over to the department officials in case they want to weigh in on this.
Thank you very much, Madam Chair. Unfortunately, I was able to hear the first part of it, but not all of it. So if you could read it again, I would, that would assist me in being able to help clarify what it does.
It may be more efficacious if the clerk emailed it to you, Ms. Kleinberg, but,
yes.
But what it's doing is trying to ensure that the provider is the one who consults, not the second person, and providing some clarity that the person who is named with the expertise is a medical practitioner or nurse practitioner. If you want, I can read it again. If the clerk.
If you could read it one more time, that would
so
that would be great.
From the top, or
yes, if you wouldn't mind, I will take notes.
Ensure that another medical practitioner or nurse practitioner has provided a written opinion confirming that the person meets all of the criteria set out in subsection 1. That's the new subparagraph E. The new subparagraph E.1 is if neither they nor the medical practitioner or nurse practitioner referred to in paragraph E has expertise in the condition that is causing the person suffering, they or the other medical practitioner or nurse practitioner consult with a medical practitioner or nurse practitioner with that expertise, or they consult and share the results of that consultation with the practitioner referred to in paragraph E. That's all.
I'm just, thank you, Mr. Varani. I'm just going to also ask the department if they can take a look at the French version of that. My understanding is that the proposed text has been emailed to you, so you should have access to it. If you can also comment if the French version is in order.
Thank you, Madam Chair. It appears that the first part, so I'm really only looking at E.1 because I think the wording for the revised E, which is the requirement to obtain a second assessment, is identical with what's currently in the criminal code. So I think that is fine. And then if I look at the proposed new E.1, it appears to be saying, so they would normally be referring to the MAID provider because all of the safeguards are directed at the MAID provider personally. So where we see they, we would read that as the MAID provider. So it appears to be saying if they, who is the MAID provider, if neither they nor the second assessor has the expertise, they being the MAID provider or the other provider would consult with a medical practitioner who has that expertise. And then there is an alternative to that, which is that the MAID provider would consult and then share the results with the practitioner referred to in E, who is the second assessor. So I'm not sure there is, it appears as though the first part of E.1 is saying that either of the two assessors could consult with the expert. And then as an alternative, the MAID provider can consult with the expert and then share the results. So there's a little bit of perhaps a duplication. If it is the second MAID assessor who does the consulting, it's not clear whether they would have the obligation to share the results with the MAID provider on this wording. If the first or were converted into an and, then it would be alternative requirements that either the two providers together would consult with a practitioner, or the MAID provider could consult and share the results with the second assessor. But if it's an and at the beginning, there's a bit of repetition and not 100% clarity as to when there would be an obligation to share the results.
Thank you for that. Can I then turn to Mr. Garrison to see if the proposed friendly amendments fulfill the purpose, or do we need to let this amendment stand for now and reevaluate the French version? Mr. Garrison, if you want to comment on that.
Madam Chair, again, I've got this malfunctioning headset, and I do apologize. I believe that this substitute wording does achieve the same goal as my amendment, and I don't see any problem if it duplicates the obligation to consult.
Okay, thank you, Mr. Garrison. I see 3 hands raised, Mr. Virani and two now, Mr. Virani and Mr. Moore. Oh, Mr. Virani is gone. So just Mr. Moore then. Please go ahead, sir.
Speaking to the amendment as amended, I didn't hear much testimony in this regard. It seems the very opposite of a safeguard. If we look at the other, and I realize this is a moving target because we're kind of all hearing about this new language and getting a translation of it in English and French in real time. But the prospect, we've heard how MAID providers, as Mr. Garrison said, are enthusiastic about removing the 10-day reflection period, while palliative care doctors are in favor of maintaining it and having a reflection period. Persons with disabilities are in favor of having a reflection period. So here we have a situation where the legislation requires that there's a written opinion confirming that the person meets all the criteria set out in subsection 1, and that is provided by someone with expertise in the condition of the person is suffering. Now, what this amendment would do is say the MAID provider would get a written opinion from a medical practitioner or a nurse practitioner confirming the person meets the requirement. To me, that at first blush, I take that as, the safeguards were here under C14, and now we're moving them down in C7, and this amendment just chips away at another safeguard, and having we've already been discussing, we discussed this on a previous amendment of ours, where death is not reasonably foreseeable, having someone with expertise in the person's condition be one of the two physicians. So here again, we're putting the MAID provider in the position of the go-between between the patient and someone with expertise in the patient's condition. To me, that's not acceptable, and I would be voting against the amendment NDP 2 as amended by the government.
Thank you, Mr. Moore. Mr. Virani, go ahead, sir.
So, Madam Speaker, with respect to what Mr. Moore just said, I think that's an inaccurate depiction of what is attempting to be done here. What we're trying to do here is ensure that the expertise that may be less available in different regions of the country is made available through a consultation exercise that would be mandated as part of the legislation under Track 2. And what I understood that the department of officials are saying is that they were providing an interpretation. I believe the amendment as it stands, as suggested by the government, would address the concerns that Mr. Garrison has raised, and I would be supporting my amendment to what Mr. Garrison is seeking to do, provided Mr. Garrison is comfortable with it, which I believe he expressed he is. Thank you.
Thank you, Mr. Varani. We'll go to Mr. Lewis next. Go ahead, sir.
Thank you, Madam Chair. Just a quick comment. I find it very interesting. The other three parties so far today have taken away a witness. They have now taken away 10 days, and now they want to add. They want to add another layer on. So it's very, very confusing on this front. My question, though, through you, Madam Chair, to Mr. Theriault, I wonder if he's comfortable with this. I don't know if he's got this in French or not, and I just want to make sure that he's got the interpretation in front of him as we have in English. Thank you, Madam Chair.
Thank you, Mr. Lewis. Madame Finley.
Thank you, Madam Chair. I am confused by this. First of all, if I'm understanding this correctly, Mr. Garrison has accepted the government's amendment to his amendment, so it's a friendly amendment. We're dealing with the two together now, as presented, as amended. Is that correct?
Yes, and the language that was emailed to you, that's the language of the amendment.
I just wanted to be clear on that. Secondly, then, I frankly don't understand this amendment at all. We tried to put forward that there should be consultation with a person who has expertise. That was defeated. The committee did not accept that, didn't accept that that was needed, didn't accept that that was necessary. Now we're talking about consulting with someone with expertise outside of the two attending people. And then why aren't we just consulting with that third party? I mean, it makes no sense to me that either expertise of in some nature, and expertise isn't even defined, so we're not necessarily talking about a specialist. We're talking about someone with expertise in that condition. There can be people who have a lesser what's the word I'm looking for? A lesser designation than specialist, who has expertise in a certain condition. Maybe they have a lot of patients with that condition or whatever. So it can be a person or a medical, now with the new language, sorry, medical doctor or nurse practitioner, etc., with that expertise. But if we're going to consult with them, then I don't understand why there wasn't support before for consulting with them and having them as one of the two people. So this makes no sense to me. And again, by doing it outside those who are attending to the patient, how is it conveyed back to the patient? How is that dealt with? There's no specifics. We're relying now on a secondhand sort of conveyance of the expertise. If you can consult with someone with expertise, then that should be one of the two people dealing directly with the patient. So I'm not
Thank you. We'll go to Monsieur Theriault next. Go ahead, sir.
Yes, Madam Chair. If the French translation, if its writing doesn't change and it stays the same it is written, I cannot vote because it's not clear. And I think that it's not translated exactly as what is written in English. There's repetition, and I would have to abstain from the vote, given that Mr. Garrison tells us that this is an editorial amendment, and it doesn't really change anything, so I would tend to keep the bill as it is because there's something really uneven in the French version of this writing.
Thank you, Mr. Thériault. Mr. Garrison, go ahead, sir.
Thank you very much, Madam Chair. I think if I hold the headset cord just correctly, it may continue to work. So two things to Madam Finley. This is a safeguard added to the second track. The previous amendment we were voting on in expertise was for the first track. So that is why the difference. And to the question of translation, I believe at the end of the committee process, we will authorize reconciliation of the two texts to make sure that they accurately reflect the sense of the bill. And so there is a chance before this is referred to the House for that reconciliation of the translations to occur. I'm not saying there's no change here. What it is, it's clarifying something that was already put into the process by Bill C7 about exactly who has to consult and how that consultation should be done. This is a problem that we run into in rural and remote communities where we do not always have people with the expertise. And this will require a consultation to take place. And yes, it may be with someone who's not even in the same community, but with someone who has experience and expertise with the condition that's causing the suffering. So it's just clarifying those consultation procedures.
Thank you, Mr. Garrison. And I understand our legislative clerk would like to speak to some of your comments with respect to the translation. Go ahead, sir.
Thank you. Thank you, Madam Chair. Yes, Mr. Garrison, when an amendment is proposed in committee, if it's proposed in both official languages, we have no say on the matter when it comes to the translation at the end of the process. It would be adopted by the committee in both official languages, as is. Now, if you were to propose the amendment just in one language, as it's possible, we would send that language, that version, to our translator at the House of Commons, and they would make sure that the French and English correspond. But if you propose the amendment in both official languages, the legislator has spoken, and then this is the will, basically, of the committee to adopt both versions.
Mr. Garrison.
Thank you very much, Madam Chair. Of course, because I am not completely fluent in both official languages, I moved my motion originally only in English, and I think we can adopt the English text if that's what the legislative clerk is suggesting, and then have the two reconciled. And that's fine with me, although I know it may not be satisfactory for Mr. Thériault.
Thank you, Mr. Garrison. And then Monsieur Thériault. Go ahead, sir.
Madam Chair, if I don't have any other choice than to abstain, I will not vote on an unclear clause.
Monsieur Thériault.
And that's not presented in my language. There you go.
If you can repeat that, sir, I missed the translation.
You want me to repeat the whole of my intervention?
Sentence, if that's okay.
I was saying that I will not be able to vote on a clause that's only presented in English, so I will abstain because I would tend to vote against it, but because the substance doesn't necessarily seem incompatible with what I would accept, but I do feel it is terrible that we're at this point here today. And I would like that to be on the record, that it be underscored, that at the very least we should ensure that a French translation would be adequate.
Point of order, Madam Chair.
Go ahead, sir.
Given the issue of translation, and given that we're now at 1 o'clock, and given that we have a number of amendments left to consider, I would move that the committee now adjourn.
Mr. Cooper, you can't move motions on a point of order.
Well, I move the motion. I make a motion.
Thank you. We'll call the vote now for a motion to adjourn the meeting. Go ahead, Mr. Clerk.
Thank you, Madam Chair. So, Mr. Cooper?
In support.
Ms. Finlay?
In support, and then we can have translation for next time.
Monsieur Thériault?
Mr. Thériault?
Against.
Mr. Callaway?
No.
Mr. Lewis?
Support.
Mr. Maloney?
Against.
Mr. Moore?
In favor.
Mr. Sanga?
Against.
Mr. Virani?
Against.
Et puis Monsieur Zuberi?
Against.
So, yeas pour 5-5 et nays contre 6-6.
So the motion to adjourn is defeated. We will continue the meeting. Monsieur Thériault, just addressing your concerns and for clarity for all members.
Point of order.
Martina,
Sorry, I didn't hear who that was.
can you close the door?
Mr. Moore, was that you?
Yes.
Go ahead, sir.
Well, in light of everything that we dealt with before, and in light of us wanting to work on this expeditiously, but within the rules as we've set out, MP Finlay raised a question of privilege earlier. We've been working on this for 3 hours now. We're having an issue with translation. What is the chair's intention? Like, what should we as MPs do when we have a meeting that's scheduled to end now? Presumably, unless, and I want an answer on this, Chair, do the other members of the committee, because Conservatives have not been made aware of the intention to extend this committee, to start it early or to extend it. So have the other members of the committee been consulted? And when do you plan to adjourn this committee meeting? Because I refuse to believe that there's no one else on this committee that has anything else in their schedule for the rest of the day. So when are we wrapping up this meeting that was scheduled to wrap at 1 o'clock?
Thank you for that, Mr. Moore. Then thank you for all of your hard work, members. Obviously, we want to get through C7 as much as possible. But a chair cannot adjourn a meeting without the majority consent of its members. We just had a vote, and the majority of the members voted to continue the meeting. And so, as my prerogative of chair, and according to the rules, the meeting will continue. We'll continue on what is in the agenda. Thank you for raising your point of order, Mr. Moore.
Another point of order, Madam Chair.
Yes, sir.
But you just said, unfortunately, is factually incorrect. The chair can adjourn the meeting when the chair wants to adjourn the meeting. If you were to bang the gavel now and say meeting adjourned, then the meeting would be adjourned. So there's no reason not to adjourn the meeting now and to pick up at our next scheduled meeting, which by my calendar would be Tuesday at 11 o'clock Eastern time. But I just want to correct that, because the meeting as scheduled, and you as chair, we have a meeting scheduled, the notice went out, it's scheduled to end at 1 o'clock. So now we're after everything we went through this morning with short notice changes to our schedule, now we're doing it all over again. So I guess the whole conversation this morning, people weren't hearing when we said that we want to try to respect each other's schedules so that we can work together collaboratively on clause by clause on this bill.
Thank you, Monsieur Thériault, and Mr. Moore, and I will refer you to page 1099 in the book of procedures that clearly lays out the circumstances under which an adjournment happens. This morning, you had questioned why members were not consulted. Here during this meeting, members had the opportunity to vote on a motion to adjourn the meeting. Members chose not to adjourn the meeting, and as chair, it's and as you had recommended in good faith earlier this morning, it is my prerogative to continue the meeting if members want to continue the meeting. And under this majority vote, members have expressed that they would like to continue the meeting, and I suggest that we go ahead and do so. Monsieur Thériault, I see your hand raised on the same point of order, sir.
Madam Chair, I would like to raise a point of privilege. Madam Chair, after the clerk's clarifications, saying that if we were to adopt this clause in English and in French, we're not going to be able to modify it, and we'll be stuck with an unworthy translation, and the only way to do it would be to vote on it in English. A colleague said that given the fact that we have come to the end of our scheduled meeting, it would be good to be able to correct the version so that it may be presented in English and French. So we'll go ahead with a vote. And I can see the Liberals saying that the two languages in Canada are important. And they're attacking my point of privilege, that is to be able to vote on a clause in my language. So I would like it to be very clear that on the record, that I'm making an objection, and I think that it is a profound insult to people who have voted, to the fact that we should be able to adjourn and to go ahead and present a clause in both French and English. If this had happened at the beginning of this session, I would have understood that, well, there are people that saying, well, but here we are at the end, we've gone over time, and we've had more than 3 hours in our session. So I would like to ask my colleagues to reflect on this meaning of the vote that they're having. And I think that this is a fundamental violation of my rights. So I would like us to reconsider, and that somebody do ask again for a motion to adjourn so that we can get back the fair parliamentary fair play, and that we respect the official language of my nation. People like to recognize all of nations, and Quebec is a leader there. But when it comes to the Quebec nation in a parliament, during a parliamentary debate on a clause-by-clause consideration, we're able to say that it doesn't matter, we could just present it in English, the clause. Well, I refuse to accept that, and I refuse that we continue to accept such a thing. So if a colleague were to ask for a motion to adjourn, I would hope that my Liberal colleagues and NDP colleagues would reconsider their vote, and that we would be able to see each other in a session where everything would come back to a much more interesting state of serenity. Because now that we simply want to put things through and adopt a bill, that we haven't accepted any amendment that would improve the bill, and we don't even have the certainty that this bill will be reviewed, because there's going to be all of a debate on whether my amendment is receivable. I think that we've gone above and beyond things today, and we're not respecting the official language of Quebecers who have the right to be heard and to vote in their language in this Parliament.
Monsieur Thériault, for raising that very important point. I will clarify, though, before I turn to our legislative clerk.
Madam Speaker, could I just intervene en français avec Monsieur Thériault?
Yeah, please go ahead, Mr. Virani.
Ce point de privilège. Donc, c'était une...
The question that you brought up is an important point, Mr. Thériault. And first of all, I would like to first and foremost apologize to you. And since I presented a motion that was only in English, and so I'm correcting the situation now. I do have, I've received a French translation for what I presented a few minutes ago, and I have sent this translation in French to the clerk. So I do present you with my apologies for what has happened. It is not right, and you are quite right to underscore it once again. At the same time, I think that it's also important to continue with this clause-by-clause consideration, and that is why I voted against the motion. Mr. Thériault, thank you.
Thank you. We'll turn to the legislative clerk now to provide some clarity.
Yes, thank you, Madam Chair. I was going to say that an amendment could be proposed at report stage to correct the French version if need be. But again, I can't presume that the Speaker of the House will select it, since it could have been done here. But it's always possible to further amend what was adopted in committee. So there is a chance there to correct the French version if need be, or the English version, depending on the case.
We do also, as a committee, have the ability to let this amendment stand while we get the proper translation of French and then move on? No?
Sorry, Madam Chair. What the committee could do is suspend basically the study of Clause 1 altogether, not just the amendment. Skip and go to Clause 2, study Clause 2, 3, 4, and so on, and then come back to Clause 1 at the end. But once the clause is started, you can't just postpone the study of an amendment to go to the next amendment within the same clause.
And so I leave it to committee members to decide how they'd like to proceed on this. And I was clarifying for Monsieur Thériault that the original NDP 2 was indeed submitted in both official languages. And the amendments, the to NDP 2, were also provided in both official languages. And we've realized with our witnesses in the Department of Justice that there was some confusion in the translation. So that is what we are trying to correct here. It is, and one of the procedural ways to be able to, sorry, Monsieur Thériault, let me just finish what I'm saying here for a second. So one of the procedural ways in which it can be corrected is if the committee only adopts one language so that the translators and the interpreters can then translate effectively into the French language as well. But I leave it to committee members to decide. Monsieur Thériault, go ahead, sir.
Madam Chair, I was going to say that the amendment was proposed by the Liberal Party in its modification, but in a French that was not adequate. And that is the reason that we're having this discussion, and that is why I'm not able to vote, because it is not clear in my language. And we were going to go ahead with a vote, and it would seem that we were going to say, well, we're going to vote on the English and we'll correct it afterwards. But as a parliamentarian from Quebec,
Excusez-moi, j'ai la parole, j'ai pas fini.
I'm sorry, I haven't finished, Madam Chair. As a representative of the Bloc Québécois, who received millions of votes, I am here to make the voices of Quebecers heard, and I will never accept to vote on a clause of a bill that is not also in my language and that would introduce unclarity. And I raised a point of privilege. I didn't ask for apologies. I asked us to adjourn the debate so that we could come back with something written that would make sense. That's it. And so I asked that a colleague would propose a motion to adjourn so that we do our homework and that we would come back in another session when things would be done correctly. It's easy to apologize after the fact, but if I don't intervene, well, we would be voting in English and I would have to abstain. And I already told you that I would have to abstain, and nobody seemed to be bothered by that. But I am very hurt by that, deeply hurt, Madam Chair.
Monsieur Thériault for raising this very, very important issue. It is my understanding that the corrected French version has now been emailed to all members. So, Monsieur Thériault, if you can please check your email, and all members, if you can just please confirm for me that you have the properly translated version in your inboxes of what is proposed as NDP2 with the friendly amendments. So I'll just give all of you a minute to just look at your emails and see if you have any comments. Go ahead. Thank you.
Point of clarification, Madam Chair.
Yes, go ahead, Madame Finlay.
I don't understand what procedure we're operating under here. There's been a point of privilege made by our colleague. We should be able to discuss his point of privilege. This may have just arisen now, 3 hours and 18 minutes into this meeting, but it may arise again. There's nothing, there may be other amendments to amendments that come up from the floor. It's about whether there's a legal translation in the French language if it's presented in English, or a legal translation in English if it's presented in French. He's raised a point of privilege. We should be able to discuss that point of privilege. And, you know, I appreciate that you're sort of trying to facilitate something here, but procedurally, we haven't dealt with the point of privilege. And I take my colleague's points that what was presented to him was not sufficient, and that he is indeed even hurt by this, which I totally understand. I would probably feel the same way if it was reversed in terms of language. He has the right as a parliamentarian to look at this. If it was at the beginning of a meeting or even midway through where we had time to digest it, that's one thing. But as I said, we're now going into over 3.25 hours here today. And, you know, there's no reason, as I said, when I supported the motion to adjourn, this would allow for a proper legal translation to be presented. We come back fresh at our next meeting with those translations in place. He may very well be supportive of the amendment, but he should have the right to see it in a legal translation with enough time to digest it and look at it. And, you know, it's a practical matter, if nothing else, but surely it is a point of privilege that should be maintained.
Thank you for that, Madame Finlay. Mr. Lewis, is that on the same point of order, or is that different? Sorry,
No,
point
it's
of
along the same
privilege.
line. Yes, it is. It's along the same lines of the point of privilege. Earlier in this meeting today, towards the beginning, all but one of us voted to allow the briefings to come to committee. And I've understood in the past that it takes 48 hours to get French, well, either French or English interpretation done. So I'm wondering, Madam Chair, are we gonna, when are we gonna see those briefing notes, and B, are we going to ensure that Mr. Thériault
You already have, sir. Just to answer your question, Mr. Lewis, and to Mr. Thériault, the corrected French language has already been emailed to all members of the committee, and I was allowing everybody a minute to go check your inboxes, review the language, so that we can vote on this properly translated, presented in both official languages, NDP 2. Mr. Garrison, I see your hand up.
Thank you very much, Madam Chair, and I am still dealing with a shorting out headset here. I want to apologize to Mr. Thériault if I left the impression that we would proceed over his objections. It was not my intention. I think my remarks ended with not acceptable to Mr. Thériault, and my intention there was if it was not acceptable to Mr. Thériault, we could not proceed with that amendment. So I do apologize. I am still dealing with this.
Thank you, Mr. Garrison. I see Mr. Maloney's hand is next.
Thanks, Madam Chair. I'm going to leave aside the irony of the Conservatives pointing out that we're late in the meeting and dealing this, and it's unfortunate we had more time. On Mr. Thériault's point, I have respect for his point of privilege, and I agree with him. As somebody who one of my many deficiencies is that I am not bilingual. If it was presented in a language I did not understand, I would want to have it translated as well, but I understand that it has been circulated now and that a legal translation is now available to us. So I'm hoping that we can take a moment, allow him an opportunity to review it in French, and then we can proceed very quickly. Thank you.
Thank you for that, Mr. Maloney. I'll just turn to Monsieur Thériault. If you are satisfied with the comments of our colleagues, as well as what the corrected French language that has been emailed to you, and if at this time, if you would like to remove your point of privilege, or how would you like to proceed, sir? Go ahead.
Madam Chair, I was clear. I appreciate that colleagues apologize. That's all. There is a point of privilege. There's a hand that's still raised. Maybe these are hands that shouldn't be raised, but I'm going to wait until people have finished their interventions on the point of privilege that I raised. What I asked was that we would go ahead with adjourning, since it's already been 3 hours and 23 minutes that we've been sitting in, that we come back at another session with the translations that we would have verified that would be in good French. That's all.
Thank you, Monsieur Thériault. And I will clarify, as a member of this committee, you are welcome to move a motion at any time. I'll go to Mr. Moore, who's next on the list. Go ahead, sir.
Well, like Mr. Maloney, I'll resist the opportunity to point out the irony that the Liberals are trying to slam this very important legislation through, having some type of timeline that they'd like to be on, when they in fact prorogued Parliament, delaying all legislation, ending all legislation, requiring that all legislation, all committee work, everything have to start over from zero. And now we have committees where, without notice, members of Parliament are being informed very short notice that the times have changed. We have the inability now of the chair to end the committee when the committee has agreed. So now we're all into this overtime session, and we're seeing rushed amendments that aren't properly translated. To Mr. Thériault's question of privilege, I don't blame him in the least for this, because it's unacceptable, and it's the result of a rush process. It's not a process that we put in place. I think that today, for the last 2 hours and 25 minutes, things have moved along very well, considering that it's our job as parliamentarians to consider each amendment. It's our right as parliamentarians to consider them in our official language, whether that be English or French. So this is the product of trying to slam through legislation with only 4 days of witness testimony, and that is not Mr. Theriault's fault. It's not the fault of the opposition members of parliament. You know, we're here, we're doing our jobs. Now, presumably, anyone who didn't know about this in advance is now canceling things that they have scheduled between now and question period. I can't believe that I'm the only one on this committee that had things scheduled. I know some of my conservative colleagues did. I presume that other members did. And now Mr. Theriault's a question of privilege. I want to say that I fully support him in this because it's his right as a parliamentarian to be able to deal with this, deal with each clause in the language, in his language, his official language. So this is a product of how things have been going. We've asked, you know, we had a good deal of discussion this morning from about 10 to 11 about how we could work respectfully with each other. And then from 11 till 1 Eastern time, I thought we did just that. We had clauses, we dealt with them, we had amendments, we dealt with them. But this is what's going to happen now is we have a member of parliament who's raised a question of privilege because of the rushed way that this is going. So we have the opportunity now. I had voted when we had the motion to adjourn, I'd voted in favor because we've been here 3.5 hours when we were supposed to be here originally for 2 hours. We've been here 3.5 hours. We all have things to do, and we have a scheduled meeting for next week. So I support Mr. Theriault's question of privilege, and I'm still in favor, of course, that we adjourn the meeting for today.
Thank you. I just want to seek a point of clarity from Monsieur Theriault. I apologize if I missed it, but Monsieur Theriault, did you move a motion to adjourn in your previous call?
Oui.
Yes. And if I didn't do it then, I'm doing it now.
Okay, well then, because that is a non-debatable motion, we'll call the vote. Mr. Clerk, please go ahead.
Yes.
Ms. Findlay?
I support Mr. Theriault's motion.
Monsieur Theriault?
Mr. Theriault? Yes.
Madam Chair, could I have just a brief moment to consult with my colleagues on
Sorry,
this
the
matter?
voting has already started, Mr. Virani. I can't at this time.
Mr. Garrison?
No.
Mr. Kellaway?
I vote to support it.
You voted in favor?
Yes.
Mr. Lewis?
I support.
Mr. Maloney?
I support it.
Mr. Moore?
I support the motion.
Mr. Sangha?
I support.
Mr. Virani?
I support.
Et puis, Monsieur Zuberi?
Je soutiens la motion.
I support the motion.
So, yeas pour 10, 10, et nays contre 1, 1.
Thank you. The meeting is now adjourned.